Hey, sound check. Can you hear me? That's a jam. I love it. Hi, Lee. Hi, Clark. How are you? I'm not a little bit camera ready. Oh, good. Excellent. All right, let's check on our favorite judge. Our favorite. Oh, good, Clark. That actually is some royalty-free music that I get from Upbeat. I'll find the artist and I'll put it in the description of the video after. I can't recall their name right now, but yeah, I will do that. I will find out. Here we go. Here we go now. Here we go. I'll try and make myself camera ready so that by the time we get to a point, you can laugh at my mug. You can laugh at my mug. We're laughing at your mug. I hope everyone is having a great day. I woke up late this morning. I woke up at 8 o'clock, which for me is like 3 hours late. I know. I really love that piece of music, though, Clark. It's so nice. Whoa, whoa, whoa.
All right.
All right.
It's the search start session. I'm just got that decided.
Thank you all. Please be seated.
Here we go. Dempsey, how you doing? Baby.
All right, let's go on the record with 23 SC 188947, State versus Harrison William Prescott Floyd. We're here today on State's motion to revoke bond filed last week. And I also received and reviewed yesterday Mr. Floyd's response. And Ms. Willis on behalf of the state, and who would be arguing on behalf of the defense?
John Morrison, Your Honor.
Morrison, okay. All right, Ms. Willis, your floor is yours.
Good morning, good afternoon, Your Honor. I'm Fonnie Willis, District Attorney on behalf of the state of Georgia. Just want to put some things on the record before we begin and then the order in which we plan to proceed. We're obviously here because Harrison Floyd is indicted for 3 counts. One is conspiracy to violate the Georgia RICO statute, which, as you know, carries a penalty of 5 to 20 years. The second count is count 30 of the indictment, the conspiracy to commit solicitation of false statements, a sentence that carries 1 to 2.5 years. And then finally in count 31, influencing witnesses, which carries a sentence of 2 to 10 years. On August the 29th of 2023, a consent bond was entered in this case. And I know that that's part of the court's official record. The state contends that Mr. Floyd, the defendant that is here before the court today, violated 3 of the 7 conditions of that bond. And those are going to be conditions 5, 6, and 7 as outlined there. The state is requesting so that there's no mistake as to what we're asking, that his bond be revoked and that he be remanded back into custody for violating 3 conditions of the bond. I tell people often I think numerically, and so I often ask that people do that along with me. 3 is going to be a theme here. We believe, Your Honor, as we talk about Ayala and some other case law, that 3 of the factors he is a risk for, and that he violated 3 of the conditions of bond. I want to put some basic case law on the record, and if it's acceptable to the court, I'd like further in Clark versus State, the trial court has authority to revoke bond.
Sometimes it works and
following a
sometimes it
hearing,
doesn't.
The trial court
Apologies.
determines that the defendant violates the conditions. Clark versus State is cited at 228 Georgia Act 219 at 221 and through 222, a 1997 case. Also, I think it's very important that the court knows that in matters of initially setting bond, the state has the burden of proving by a preponderance. I think that's going to be important. A preponderance of the evidence that the trial court should deny bail to protect the community, and that comes straight out of Ayala, which I would say is the seminal case on bond. We'll also be providing the court White versus State, which is at 307 Georgia 601, and it just says proof by preponderance simply requires that the evidence show that something is more likely to be true than not. And I will have to make sure my colleagues provide White versus
No,
the
it's
state.
the operator error, as usual.
White versus the state is a Georgia Supreme Court, 307 Georgia 601, 607, 2020. Your Honor, understanding we have the burden in today's hearing, the state's plan is to call 3 witnesses. Those witnesses, again, 3 being our theme, is Assistant Chief Michael Hill. We plan to call Gabriel Sterling, as well as as well as Attorney Von Du Bois to meet the preponderance of the evidence standard. With that, I don't know if the defense has opening, but as you direct, we will call our first open witness.
Mr. Morrison?
Good afternoon, Your Honor. One of the things I'd like the court to keep in mind is the spirit of this bond order, which was essentially to make sure that my client doesn't intimidate any witnesses or that he doesn't collude or with other witnesses regarding what their testimony may be. I believe when the court looks at the complained about tweets, you're going to find that that never occurred. It was never his intention either, Your Honor. I believe the court will look through, and after it hears the evidence, will find at most, if he came close to the line, the court will have an opportunity to address that. I don't believe that he should be remanded back into the custody of the state. There's no need for that. One of the things that bothers me is if these tweets had so angered or bothered the state, they would have picked up the phone call and called the defense team of my client and said, hey, listen,
Oh, is
he's
that how it
making
works?
tweets. We don't like them. Can you do something about them? And we could have addressed the issue. Instead, they simply filed a motion.
Right?
We believe the reason they filed that motion is my client is showing just how weak the case against him is.
Oh,
And I think he has a right to do that. This is political speech, Your Honor, and they're trying to silence it.
well, he's not running
Thank
for office, is he?
Your Honor, may the state call their first witness.
Bob's like,
Call
no,
Assistant
I'm
Chief
done.
Michael Hill.
Come on.
Your Honor, and we will ask that after Mr. Hill concludes his testimony, that he be allowed to stay in the courtroom.
Your Honor, we would invoke the rule.
No.
Your Honor is aware of the law that regarding detectives and investigators on cases. This is the case that Mr. Hill is working.
Well, he's about to testify, so I don't think he would need to go anywhere. But you're saying there's two other witnesses. The rules of evidence technically don't apply to bond hearings at all, including the rule of sequestration. But if there's anyone that would like to voluntarily step outside because they think that would be optically better for their case, they may do so. All right, Mr. Hill. So
Would you like me to swear him in?
I think we have Deputy Scott for that.
Well, for the testimony you should give in court today will be the truth, the whole truth, and nothing but the truth.
Yes, I do. Thank you, sir.
Please state
Oh,
the swear your full
wow.
name for the court.
Yes, sir. My name is Michael, Michael, middle initial L, last name Hill, the second.
Good morning, good afternoon, Assistant Chief Hill. Will you please tell the court where you are employed and what your title is?
Good afternoon, madam. Yes, I'm employed with the Fulton County District Attorney's Office. I currently serve as an Assistant Chief Investigator.
And in your capacity as an Assistant Chief Investigator, have you been assigned to work on what we'll refer to as the election interference case, the case that has us in court today?
Yes, ma'am. I've been so
Not
assigned for
intimidatable.
about 2 years now.
As a result of that assignment, have you had the opportunity to subpoena
Oh,
witnesses
I'm
for
telling you right
proceedings in
now,
this
the
matter?
style
Yes,
is
ma'am, I have.
off
And
the
also to
charts.
interview witnesses in the matter?
Yes, ma'am, I
Amazing.
have.
Have you also had the opportunity as an assistant chief
Atlanta's such a
to
stylish town. I'm
be
telling you.
familiar and aware with the social media pages, both of defendants as well as witnesses and victims in this case?
Yes, I have. That's correct.
May I approach?
You don't need to ask permission if it's your witness.
I am going to hand you.
Don't tell her what to do. No, I'm just kidding. No, don't lose your exhibit.
We'll take a minute and look at
Hi,
one
Elf.
and
How are you?
three.
Welcome.
1 through 21. Will you take a moment and look at exhibit 21?
And while he's doing that, I just want to note for everyone, our court reporter is joining us remotely. So at any time you're away from a microphone, just speak up.
She is just doing her job. Yeah. I really appreciate her taking this on. It would be big for any county DA.
Have you had an opportunity to look at 1 through 21?
Just a moment.
No foolishness. That's right, Joe. Absolutely no foolishness. Here to get to the point. I love it. There's too much evidence.
Yes, ma'am.
And are you familiar with exhibits 1 through 21?
I am.
Are you familiar with all of them in the same way?
Yes, ma'am, I am.
Okay, and can you tell the court how you're familiar with 1 through 21?
Yes, ma'am. So I'm familiar with exhibits 1 through 21 because they display the social media pages, specifically X, formerly known as Twitter, of defendant Harrison Prescott Floyd, as well as witnesses Mr. Gabriel Sterling, and also Secretary of State Mr. Brad Raffensperger.
Your Honor, at this time, we're going to ask that State's Exhibit 1 through 21 be admitted into evidence.
Your Honor, I'd ask the court to allow me to order the witness as to the foundation of these prior to accepting them as tutored and evidence.
You challenging the authenticity of these?
Yes.
All right. I'll give you some leeway there.
Interesting.
Mr. Morrison.
Would you like me to do that now? If you would, sir, you're familiar with these exhibits, correct?
Yes, sir, I'm familiar.
Next to the name, there's a little symbol. Is that correct?
Yes, sir.
What is that symbol?
There's an @ if that's what you mean. The name of the page.
Blue check mark at the end of the names.
Oh, no.
What is your?
Are you
I'm not sure.
kidding me?
Yeah, that'd be a
You may.
Are you kidding me?
Are you yourself a Twitter user, sir?
No, sir. I don't have any social media.
I see.
I don't
Okay.
use social media at all.
If I may, you'll notice here next to Harrison Floyd's name is what?
It's an American flag.
Okay. Next to Mr. Sterling's, there's nothing. But if you look here, what is this next to Miss Ellis's?
Yes, that's a check signifying that her account's been verified.
But
Or
the
that she
account has
pays
been
$8 a
verified.
month?
Correct.
Mr. Floyd's account's been verified?
Oh, my God. This
Well,
is your
according to
evidence?
Your example, there's no blue check next to his name. So I would imagine that means that
This
his
is your
account has not been verified.
evidence?
So have you verified that these in fact are tweets, those which purport to be from Mr. Floyd are actually in fact from Mr. Floyd?
So you're asking in terms of my authentication or how I verified that these tweets coming from Mr. Floyd, or are you asking me to give you that answer?
Have you verified that they came from Mr. Floyd?
So the way that I verified, if that's your question, the way that I was able to verify that these are tweets that were, in fact, that came from Mr. Floyd, were for a few reasons. If you look at Exhibit 1, under Mr. Floyd's page, he has there's several comments. One's God's child. The next is Erica's husband. The next is Harlan's dad. The next is a U.S. Flag that says USMC veteran. The next is 2020 at Team Trump campaign. And then the next is one of 19 defendants in Fulton County. And then lastly, you'll see where it says, or underneath all that information, there's a location symbol, and it says North Bethesda, MD, for Maryland. As a part of our investigation in this case, one of the ways that we were able to verify or actually able to state that, unequivocally this is his page, is that first and foremost, look at the second thing that I mentioned, Erica's husband. Mr. Floyd is in fact married to Miss Erica DeMare. The next is you'll see Harlan's dad. And then there's also a little symbol, an emoji symbol of a little girl next to Harlan. Not too long ago, Mr. Floyd and Mr. Mare actually just had a daughter, and I believe her name is Harlan. Also next to that, where you see the U.S. flag, USMC veteran, Mr. Floyd is also a former Marine or U.S. veteran.
I'm waiting
Next,
for the
when you saw, when I
ISP
just
or
stated the
something.
2020 at Team Trump campaign, during Mr. Floyd's time, or defendant Floyd's time here in the state of Georgia, he was actually a part of and associated with, I believe, the president of Black Voices for Trump and a supporter of the 2020 Trump campaign. And then the last thing that I'll state here is you see one of 19 defendants in Fulton County. Defendant Floyd is in fact one of 19 defendants on this indictment.
Okay. If I may, continue on. So you're
Yeah.
telling me,
Well,
Your
Mr.
Honor, I think we
Morrison,
could cut to
let me,
this.
let me just kind of cut to the chase here. If you're trying to challenge these saying or reserve the objection that Mr. Floyd did not actually send these tweets or make them,
Do it on cross.
is that what you're trying to do in terms of the
Why doesn't
authenticity?
he do it on
the
cross?
authenticity and the basis for these, I believe the state has the burden. I'm trying to hold them to their burden.
All right. And although you refer to this multiple times as posts by Mr. Floyd in the opposition's response.
Oh,
Okay. So we're going to admit them over the defense objection. And I think they've been tendered as posts that he gathered from Twitter. If you want to retain your argument that Mr. Floyd did not actually post these, I think that goes to the weight, not the admissibility. So we can continue.
And just while we're on that line, did you also see live
Oh.
images, videos, shall we say, from
God,
the
those pesky
handle that has just been
responses.
referred to by the defense? And those live images, were you able to see defendant Harrison Floyd posting himself, giving live speeches, we'll say, from that particular handle?
Yes, Madam District Attorney, that was
Oh,
actually the very
fuck,
next
she already
statement.
knows
I
about
have
the
the live
spaces.
feed or live video. If you,
And who was the person that was posting them?
Mr. Harrison Floyd.
And did the person who posted them in the live speeches that you watched, did it look like the defendant that is here in court today?
Yes.
I will stipulate that that was Mr. Floyd and these videos online.
All right.
Oh, will you? Good idea. Hi, Pepper.
Your Honor, I believe 1 through 21 have now been admitted.
Hi, Melissa.
And
She
you
knows
just
about
described in
those
great
guys.
detail for defense counsel, state's exhibit number 1. Is that correct?
Yes, I did.
Okay, I'd like to move on then to state's exhibit number 2.
She's going
Can
through
you
it.
please
Oh, I
describe
love
for
her.
purposes of the record what
God.
state's exhibit number 2 is?
State's
I love
exhibit
smart
number
people
2 is
so
the
much.
X
Smart people are the
page of
best.
Mr. Gabriel Sterling, the current COO for the Georgia Secretary of State.
And have you confirmed that this is in fact Gabriel Sterling's page?
Yes, ma'am. I have so confirmed by just myself viewing the page and throughout the course of our
Now you'll
investigation.
stipulate
And
it?
I've also spoken with counsel for
You
Mr.
think?
Sterling, who also confirmed
That's what I'd say
that
if I
that
were
is
the
his
judge. You
client's
think?
Twitter page or X page.
State's exhibit number 3, will you describe for purposes of the record what state's exhibit number 3 is and what, if any, knowledge you have on state's exhibit number 3?
State's exhibit number 3 is the X page for the Georgia Secretary of State, Mr. Brad Raffensperger, and the same I confirmed through counsel and also by way of this investigation that is in fact his official page.
Okay, let's move on, sir, to state's exhibit number 4. Will you please describe for purposes of the record what state's exhibit number 4 is and what have you confirmed it in any way?
State's exhibit number 4 is Miss Jenna, witness Jenna Ellis's X page. That was the page that defense counsel referenced the blue check mark next to her name. And I'll also confirm by way of this investigation and also by way of her counsel that is her, in fact, her official page.
State's exhibit number 5, will you describe for purposes of the record what it is and if you have in any way confirmed its authenticity?
Yes, ma'am. That is the X page or Twitter page of the Fulton County District Attorney's Office. And I confirm that through Madam District Attorney.
And if I may, Ms. Willis, if we're doing this for 6 through 21, I think maybe the stipulation would cover this.
Yes, Your Honor, but thank you. We're going to get to content at this point, and I am now at state's exhibit number 6, which are relevant to the bond motion.
Isn't it beautiful, Lee? It's
May I
a
proceed?
beautiful thing.
Of course.
State's exhibit number 6.
What a gorgeous picture.
State's exhibit number
Lee, I love
6 purports to be from whose page?
Mr. Harrison Floyd.
And what, if anything, can you read into the record the content of state's exhibit number 6 and what it states?
Yes, the content, it states that passing this along
Seriously.
to
I
Georgia
think nobody
at Georgia
watches
Secretary of State
everything else they
and
do.
at Gabriel Sterling. Should they be more concerned about interfering in elections, perjury before Congress, lying to DA Fonnie Willis, or all the above?
And the at Georgia Secretary of State and at Gabriel Sterling is where I want to draw your attention. Have you confirmed that by tagging those
Right.
posts that they did in fact
it's beautiful.
contact witnesses in this case?
Yes, ma'am, they did contact, and my understanding is that Mr. Gabriel Sterling, in fact, has seen this particular
I hope this sets the stage for others.
notification or communication, rather.
You know.
So this post that tagged Gabriel Sterling was able to communicate with him.
Yes, ma'am, that's correct.
I have now drawn I'm going to ask you to bring your attention to state's exhibit number 6. State's exhibit number 7. Who is
hope
state's
it was
exhibit number
worth
7
it.
for? What is that?
Once again, this is
I just
Defendant
hope it
Floyd.
was worth it.
And what is the content of state's exhibit number 7?
The content is all caps, "We want the truth," followed by 5 exclamation points. And he ats Georgia Secretary of State, at Gabriel Sterling, at Fulton County DA. Next, it states, "It's accountability time," with a clock, and then "unseal the ballots."
through your investigation, were you able to confirm that by placing the at Georgia Secretary of State, that communicated
Honor,
with
defendant
members
is
of the
simply
Georgia
not smart
Secretary of State's
enough.
office?
Yes, ma'am, I have.
Why is he taking the
Subject
fall for
cross-examination. He has no
everyone?
personal knowledge of how
I
it
know,
works,
there you
how
go.
X works. He already said he didn't. So I don't know how he could possibly know that that's communicating with.
As Your Honor is very well aware, hearsay is allowed in a bond motion, and I believe he can testify it through hearsay testimony.
I didn't
Look at that
object to
face. I love her.
No, just speculation.
Don't fuck with
personal
me.
knowledge.
It's noted, and I think that goes again throughout this hearing. It'll be its weight and not its admissibility, and certainly something you can argue.
All right, sir. Thank you.
How do you have knowledge? Let's specifically go to first of all, is Mr. Sterling a member of the Georgia Secretary of State's office?
Yes, ma'am, that is correct.
And were you able to communicate with him?
Yes, ma'am, I have.
And through that communication, you learned that he was able to see the post at Georgia Secretary of State?
Yes, ma'am.
Was he able also to see the post that tagged him at Gabriel Sterling?
Yes, ma'am.
And so do you have first knowledge through that communication that this post communicated with him?
I have personal knowledge that Mr. Gabriel Sterling has viewed these communications, has seen them. Yes,
And thus they communicated with him.
correct.
I would like to draw your attention to State's Exhibit number 8. Please read into the record the content of State's Exhibit number 8.
Once again, this is from the X page of Defendant Floyd, and the content is as follows. Black American Dems want the Black Trump guy to tell on the racist white Republicans, but only if it's President Trump, ? LOL. Look, the truth is that at Georgia Secretary of State and at Gabriel Sterling are the pieces of, and it's a
Emoji, can you just spell that word as opposed to put profanity in the record?
Yes, ma'am. It's an emoji of poop or fecal matter emoji. They are the pieces of that emoji you should be mad at.
Emoji.
Make elections fair again. And yeah, that's it.
Is there 2 hashtags after that, sir?
Oh, yes, ma'am. The hashtags underneath are #fraud and #Fulton.
Let's move on to State's Exhibit number 9. Can you please read us the content of State's Exhibit number 9?
There you go.
State's Exhibit number 9, once again, comes from the X page of Defendant Floyd. And he states, it's over with 5 exclamation points. At Georgia Secretary of State needs to call his lawyer. He's about to go through some things, exclamation point.
Poor
#fraud,
guy.
#cheating,
I don't envy that.
#election interference.
Moving on to State's Exhibit number 10. Will you please read into the record the content of State's Exhibit number 10?
Once again, from the page of Defendant Floyd, the content is, wow, at Jenna Ellis Esquire, you're a whole mess, girl, exclamation point. So you didn't stop at stealing people's hard-earned money
Yes, he
for
is,
your,
isn't he?
in quotations, defense. You're also lying on at Dan Scavino with a question mark, exclamation point, question mark. I guess they don't teach ethics at Harvard Law anymore. And then there's an emoji that I can't make out. #give back the money.
I need to stop here and ask you a question. Is Gabriel Sterling a witness in this case?
Yes, ma'am, he is.
And in fact, specifically to this case, did he testify at a proceeding?
He
Multiple.
probably has kids.
Did he testify specifically at the
If you have a kid, you know poop emoji.
special purpose grand jury?
Yes, ma'am, he did.
And were transcripts of that testimony turned over to the defense?
Yes, ma'am, they were.
Okay, moving right along, Jenna Ellis, what
It's an
was her
eggplant.
initial status in this case?
Her initial status was one of the 19 defendants.
And what is her status at this time?
She has since pled and she is now a witness for the state.
Did the proffered testimony of Miss Ellis,
It's a
was that
drag.
turned over as witness testimony to the defense in this case?
Yes, ma'am, it was.
I like mine
Moving
better.
right
I like
along,
the
let's move
eggplant
to
better.
State's Exhibit number 11. Do you have State's Exhibit number 11
Or like
for you?
squirt.
I do.
Can you please read into the record what the content is of State's
Sorry.
Exhibit number
I'm
11?
12 years old today.
It's again
Sorry.
from the page of Defendant Floyd. It states, if we are sharing / leaking videos today, ... and then there's an emoji. Like I said from the start, Ruby Freeman was all caps terrified and wouldn't talk to anyone, all caps white, exclamation point. Why, ... question mark. Because racism and political terrorism in, I believe this is an emoji of a peach, is still very real, exclamation point. This is a all caps cover up.
Oh my
And Fulton
Lord.
County
Harrison,
is all
you
caps
went balls
corrupt.
deep on
There
this.
is an
Jesus
image on this
Christ,
particular,
on a cracker. Yeah, blah.
print
Can I
out
ask it
what
back
is that
in?
image so that the judge knows exactly what it is he is looking at in
Yikes.
State's Exhibit number 11.
What didn't he post?
Your Honor, that is an image of the body cam from the Cobb County Police Department of Miss Ruby Freeman at her home.
Let me ask you,
Did he go poop? Oh no, that's the other part.
do the basis of the initial charges in this case against Mr. Floyd, do they involve Miss Freeman?
Yes, they do, ma'am.
And to your knowledge, is Miss Freeman listed 40 times in the state's indictment in this case?
She is approximately thereabout, yes.
And is that surrounding the charges against this particular defendant?
Yes, it is.
And this is an image from evidence in the case that is displayed on State's Exhibit number 11.
That is correct.
Good idea.
Can we move on to State's Exhibit number 12? Can you please put into the record what is displayed on State's Exhibit number 12?
Again, from the page of Mr. Harrison Floyd, this is a cover-up, all caps, and Fulton County is corrupt, all caps, with an exclamation point.
I think if I were him,
Is
I
once
might
again that
sit up
same
a little
image
bit.
of Miss
I don't
Ruby
know.
Freeman at her home via Cobb County Police body cam. And
Yes.
underneath the image,
Right.
it says, so this begs the question, if Ruby Freeman didn't trust white people to help her, what did she say to the Black people that offered to help her? I'll wait for you to get your popcorn.
Is there a response? And please do not put any profanity. I'd ask you to spell out the word that is profane underneath that comment.
Yes, ma'am. There is a comment. It comes from underneath this post, and the comment comes from at Full Ford Leonard, and the statement is bury this BITCH under the jail.
All right, let's move on to State's Exhibit number 13. I believe the top of this post you just read, there is in this one a different depiction. Are there words
right,
now,
there's
and
ways.
who is that an image of on this post?
Once again,
Yeah,
it's,
go.
I'm sorry, you said State's Exhibit, which number?
I'm sorry, 13.
Okay.
Timestamp
Uh,
that shit.
Words in the, first of all, what is that an image of?
It is an image of, once again, Miss Ruby Freeman at her home via Cobb County PD body cam.
Okay, and are there words in that particular depiction that were not present in State's Exhibit number 11 or 12?
Yes, ma'am, there are.
Will you read into the record what those words are?
Those words state, he told her that he wanted to help me.
Is there a comment beneath that in State's Exhibit number 13?
Underneath, there's a comment
Right.
from at brunettes.
Yeah.
Brunettes
right?
are great. And the statement or the comment is Ruby should be in prison with an angry emoji face.
Okay, let's move on to State's number 14. Is what's at the top of State's Exhibit number 14 simply again
what a
the
fucking
image
asshole.
of Miss Ruby
I'm
Freeman?
sorry.
Yes, ma'am,
Objectively,
it is.
sir, you're an
And
asshole.
can you please read
about
into,
that?
and there's the same text
The
from
fuck
Harrison
is it?
Floyd that
Where's
was
your
displayed
mother?
before, correct?
That's correct.
In an effort
That's
to
what I asked myself.
not
with these
use as much
bullies.
time,
I'm like,
can you
where's
just
your
get us to
mom?
what the comment is under that one?
The comment from at MS Miss Tish TSH 80 is Ruby the racist. Who would have thunk?
Do you consider those to be positive comments?
Not at all, ma'am.
Let's go to State's Exhibit number 15.
Oh, I bet.
Again, the same post from Mr. Floyd.
Jesus,
there are
there's something
different,
wrong
there's
with
an
that
image
dude, I
again.
think.
Who is this image of for purposes of the record?
Miss Ruby Freeman.
And are there different words that were displayed on the previous post?
They are the same words. He
Harrison,
told her
look at
that he
the-
wanted to
his
help
lawyer is
same
like,
words.
I am so fucked.
Image from the body
What the
cam.
fuck am I doing
in this
here?
case?
That is correct.
Why
And does
didn't
it
I
display
just
the
take
witness
those
Ruby Freeman?
ambulance
It does.
chasing
Is that the same as
cases?
Ruby Freeman that is listed 40 times in this
They
indictment?
think
Yes, ma'am, it
that
is.
since
What is the
Trump could
comment
do it, they
underneath?
could do
The
it
comment
too,
underneath
and
is
they
from
can't.
at Justine
That's what all his followers think.
01848685, and it says racist. And then there's a pig
Clayberg,
emoji.
I love.
Did you find that to be a positive comment?
Not at all, man.
Movie night
Moving
tonight
on
for
to State's
members.
Exhibit number 16. I believe that this is a different post. Is that correct?
It is a different post.
Will you, for purposes of the record, read into what the
I don't know if
content
I
of
can
this
make
post
people
is?
members.
Again, it comes from the page of Defendant Floyd. It states, yesterday, the Fulton County DA's office leaked proffer videos, and now they are trying to blame my team in
Oh,
order to get a
great.
protective order. Look at
Hooray.
Fonnie for DA. If I was going to leak something,
Hooray.
it wouldn't be Sidney Powell or Jenna
It's
Ellis.
gonna be fun.
It would be this.
I have a special already set
Hashtag
up.
Georgia, hashtag fraud.
And then what, is there an image beneath that?
There is an image, yes.
And what is that image displaying?
The image is displaying the audio captured from the body cam of the Cobb County Police Department.
And who is it capturing, whose voice?
It's capturing the voice of, I believe it's Miss Ruby Freeman, if I remember correctly. Yes.
And let's just, for educational purposes, that at Fonnie for DA, because that at Fonnie for DA was there, do you have personal knowledge if that communicates with me?
I do have personal knowledge that you have, that it does communicate with you.
If she would like to testify, she can take the stand and testify that was communication with her. I mean, this is getting trying to give latitude.
Or I can use
Who are
hearsay.
you?
Yeah,
Are you
I
being
think it
let
comes in
alone?
through here.
State's
So
Exhibit number
Is that how you call? Is that what you call that?
State's
Yes.
Exhibit number 17.
Yes,
is that-
17.
10:30.
17.
Can you
So
please refer to
1:30 your
State's Exhibit
time
number
or
17 and tell us what the
10:30
content is?
Pacific.
Yes, again, once again, it's from Defendant Floyd's
Not very
page.
long
The
ago.
content is, so if there is no protective order,
Yes,
Here's the
African America
911
is
call
Mike
that
Lindell's
shows.
girl.
no threats were made, check. Ruby Freeman wanted them to, all caps, come back and tell her what we could do for her, check. Ruby Freeman set up the meeting at the police station, not me, check. And then all caps, I did nothing wrong, hashtag Fulton County, hashtag fraud.
Let's move on to State's Exhibit number 18 at this point. Does State's Exhibit number 18 show that exact same post you just accounted in State's Exhibit number 17?
Yes, ma'am, it does.
Can you please read underneath that particular post from defendant Harrison Floyd what the comment was?
The comment underneath the post is from @South40me, and it states, the whole world knows what she and her daughter did. Absolutely shameful, and all caps, treason.
I'm confused. Is that positive?
No, ma'am, that is not a positive comment.
Objecting and
moving-
judge, we strike that last response. Whether he thinks it's positive or not, it's commenting the evidence. You're the fact finder. You can determine.
All right, I'll overrule for the purposes of this hearing.
State's Exhibit number 19. Is that before you, Assistant Chief Hill?
Yes, ma'am, it is.
Can you read into the record what the content is of State's Exhibit number 19?
Once again, this is from Defendant Floyd's
But no
page.
swearing.
The content is, why would my team leak Jenna Ellis and proffer videos when there is better stuff? For instance,
Right.
Ruby Freeman's job was the reconciliation of ballots. She wasn't even supposed to be on
I
a
don't
scanner.
know.
5
I don't know where you
exclamation
are,
points
Badger.
follows that. Hashtag fraud, hashtag Fulton
Oh.
County, and hashtag
I didn't realize it. I
GEORG.
should've followed
for
him. I didn't
Georgia.
follow
And
him
then
on
what is
Twitter.
the image that is displayed underneath that?
Underneath, it's an image
What a
that
dick.
captures audio, and it's purportedly the voice of Miss Ruby Freeman, captured from the official body cam of the Cobb County Police Department.
And I want you to move along to State's Exhibit number 20. The same post that was in State's Exhibit 19 is also displayed in State's Exhibit number 20. Is that correct?
YouTube.
Oh, actually,
No,
I
ma'am,
apologize.
it's a different post.
Let's move
I don't
on to
know.
State's Exhibit
I
number
only see
20.
you
What does
once.
State's Exhibit number 20 state?
I'm
State's
pretty
Exhibit
high.
number 20 states, again, it's from the page of Mr. Harrison Floyd. Does this sound like Ruby Freeman is being, all caps, pressured? Why would DA Fonnie Willis want to hide this from the public? Hashtag fraud,
Where is
hashtag
this
Fulton
dude's
County,
mom?
and hashtag Georgia.
Where?
And
Going
there is an
after a
image, and
woman.
who is the image purported from?
But, oh,
Miss Ruby
Jesus
Freeman.
Christ.
And is it again the body cam video?
So weird.
That's correct.
Can you
Or
please?
audio.
I'm sorry, body cam audio. Can you please state for purposes of the record what the comment is underneath?
The comment underneath is from Gandalf 419781.
Sure.
And the comment reads, Miss Ruby needs a bodyguard or she's going to get Epstein.
What does Epstein mean to you?
What it means to me is it refers to Mr. Jeffrey Epstein, who was a defendant, rather convicted individual in a sexual assault or sexual of nature crimes that he committed years ago. And during the year, I believe August of 2019, he was actually incarcerated and found hanging from his cell and is now deceased.
Okay, so is that a term, you're going to be hung from your cell? Is that the way you read that?
The way I interpreted.
Well, let's clear one thing up. I think we need to have one attorney at a time conducting the hearing, so y'all can choose between yourselves.
Your Honor, we'll move on from this point.
All right, and just to rule on the objection, his characterization of it is not going to be definitive, but overruled for the purposes of the record. All right.
Do all persons in your do most people need bodyguards in your knowledge of the world?
I wouldn't say most people, man.
How about those threatened?
Those threatened, sure.
Let's move on to State's Exhibit number 21. State's Exhibit number 21 before you.
It's crazy.
Yes, ma'am.
What, if anything, does State's Exhibit number 21
I feel like it's almost
depict?
like a
It depicts the same image and the same
intentional provocation.
comments from Exhibit 20.
And what, if anything, does it
I
state?
wouldn't put it past them to get together and
I'm assuming you mean the comment?
do this. We'll
first of
back
all,
you
let's
up.
read what
There'll be a great payday at the
Mr.
end.
Floyd's post states,
Just
as well
take
as the
the-
image, and then the
take
comment
the
and
L.
response.
Yes, ma'am.
he's probably
It
like,
states Exhibit
okay,
21. It states the
there's enough
comment,
money
excuse
for
me, the
that.
post actually states, does this sound
That's
like
the
Ruby
only thing
Freeman
I
is
can
being
really think
pressured,
of.
all caps? Why would DA Fonnie
Isn't it?
Willis want to hide from the public? Hashtag fraud, hashtag Fulton County, hashtag Georgia.
I feel like
Again,
this
is
is
the
all part
image
of the
of
scheme.
audio
The
PD body cam
the-
from Miss Ruby Freeman.
dump side.
And then the
working.
comment is from at Smoky Mount Mystic. And it states, Ruby is going to get virtually slaughtered under cross-examination at Trump's trial, and Fonnie will face charges herself. And then there's a parenthetical, if she's allowed to live till then.
Oh,
and-
Ms.
no.
Freeman is allowed to live to testify.
I'm not certain, throughout the course of my investigation of this particular post, I'm not certain if Mr. or Defendant Floyd is referring to Madam District Attorney or if he's referring to Miss Ruby Freeman.
Objection, Your Honor.
Oh,
Neither of these,
I'm
this
not gonna-
comment wasn't made by Mr. Floyd. This comment was made by a third party. To
Correct.
characterize this as Mr. Floyd referring to Fannie or Ruby was incorrect.
I misspoke, Your Honor. I
It's Fonnie.
We can clarify
but
that further.
yeah,
you-
it's funny.
So that the record is clear,
Very much.
this is a post in response to Mr. Floyd's post related to Ms. Freeman.
That is correct. I misspoke. I meant to say the comment was, it was unclear if the comment was referring to Madam District Attorney or,
I would live or if she would live.
correct.
One of us
correct,
might not make it.
Correct.
Oh my
Correct.
God.
And this is in response to
Do we argue
this
that
defendant's
point?
post.
It's in response to
I don't
Defendant
know if
Floyd's
he
post.
did or Marie. I think there was another
As
young
part
woman
of
who
your
used to work for
continued
Kanye. I don't
investigation
believe
at
Mr.
this
Floyd ever
time,
worked for
Did you have an opportunity to communicate with defense counsel
I
for
can see you, Badger.
Jenna Ellis?
Correct, I have.
And in fact, were you able to determine that those tags
But the other
effectively
woman who,
communicated
harassed
with Ms.
Ruby
Ellis?
Freeman,
I did determine that those tags, in
who I
fact,
believe worked for Kanye.
certainly communicated
At a
with Miss
point in time.
Jenna Ellis.
Meaning that when she was tagged, that allowed her to see the communication from Mr. Floyd.
That's correct.
And in fact, in response to that inquiry, I'm gonna hand you
Yes.
what has been marked as State's
Right.
Exhibit number 23.
Oh, great. Oh, I've seen him interviewed.
Can you
He's terrible.
silently to yourself,
I'll pull them
State's
up.
Exhibit number 23. Have you had an
11,
opportunity to do so?
11.
Yes, ma'am.
I don't know what
And
that
is
means.
this a communication from the now previous co-defendant, but now witness in this case?
Yes, ma'am.
And was the inquiry made as to both whether these posts communicated with her and whether she was intimidated by them?
Yes, ma'am. That's true.
And is State's Exhibit number 23 a text message to that effect?
Yes, ma'am, it is.
Your Honor, at this time, I'm gonna ask that State's Exhibit number 23 be admitted into evidence.
Your Honor.
Mr. Morrison.
My objection to this is it doesn't have any foundation. It doesn't indicate a time or a date. This is just out of the blue. There's nothing on this that verifies this. This is just
I don't even
Run
know
hearsay.
that
Ask the court if it admits it to give it the little weight that it would deserve.
So I don't have a copy of any of these exhibits, so I can't really speak to what's on it or what is not. But if there's any more you want to lay, and then we can revisit the objection.
So what I've put in State's Exhibit number 23, how did you receive that?
So the contact that you just referenced with defense counsel for Ms. Jenna Ellis was with Mr. Mike Melito. I contacted Mr. Melito. I asked him the questions that you just mentioned about whether or not Ms. Jenna Ellis was communicated with by virtue of these tags, and if she felt threatened or harassed by these communications. And this is the response that Ms. Ellis provided to her counsel, and her counsel provided to me.
And did he also state this to you verbally as well?
He also stated this. He actually read this out to me. Yes.
So you received it through him verbally telling it to you, and then he memorialized it via this text message.
That's correct.
And for purposes of the record, was this sent to where?
It was sent to my Fulton County issued cellular device.
Do you have that with you?
I do.
Do you have it on you now?
I think I left it.
Let me ask you this. At approximately what time did you receive that? May I approach?
It's your witness. I didn't know that. I didn't know if it's their
Thank you.
witness, they could go ahead and approach. Because I would think that they would have had to
Open
have
up the
it.
message.
Okay. Now I get it.
Yes.
Now I
And
can be a
at what time what day did you receive that though, so that we're clear for the record?
Today, Tuesday, November 21st, 2023.
And at what time?
This morning at 10:59 a.m.
And this was, again, he spoke this to you verbally
Yes, ma'am, that's correct.
and then memorialized it.
Yes, ma'am, that's correct.
Your Honor, at this time, I would ask that State's Exhibit number 23 be admitted for purposes of this hearing only, and that he be allowed to read it into the record and that it be admitted.
All right, Mr. Morrison, you renew your objection on authentication.
No, Your Honor.
All right, Exhibit 23 is admitted.
Can you please read it for purposes of the record?
So in the message, Ms. Jenna Ellis states, I saw it a couple days after it was posted. Yes, I believe it was meant to both intimidate and harass me, and also encourage others to harass me, which others have done in the comments and separate posts following this post, and Floyd's comments about me on media. And then there's in the parentheses, which the DA references in their pleading.
One moment, Your Honor.
1 minute. It just takes a minute. Well, hello, Mind Truth Word Life. How are you? Welcome. Nice to see you. Today was the last day he ever forgot his badge. That's right.
Moving to another line of questioning.
This is wonderful question.
In your investigation on Mr. Floyd, does he have other names that you're aware of?
Yes, Willie Lewis Floyd III is another alias for Mr. Harrison Floyd.
Does he also have in your investigation other open criminal charges?
Yes, ma'am, he does. In particular, federal charge
Is this the
for simple
FBI?
assault against two
Yeah.
federal officers.
Yeah.
Your Honor,
Another further?
specifically, that's not a matter that was raised in your motion to revoke the bond. Bringing it up here and now, that's the basis upon which they asked the court to rule, would deny my client procedural due process by springing it on him in the middle of this hearing.
All right. Well, Mr. Morrison, if that's a line of argument that you think you need more time to respond to, and you need to articulate how that extra time you need, you can do that, and we'll go from there. All right. I think it's Mr. Hill's for cross-examination.
You said that you're not familiar with social media.
No, sir. No, that's not correct.
Well, you're not very familiar. You don't use social media.
In my personal life, no, I do not.
Understand. Now, you said that these are direct communications, is I believe how you characterize that. Is that correct? May I approach, Your Honor?
You may.
I'm going to hand you what's labeled as Exhibit B for the defense.
May I approach
Are you familiar with this?
Cry.
Yes, I'm familiar, but you just said that I characterized something as direct communications, and I didn't. I didn't say that.
Okay.
Yeah, I don't know where you got that from.
All right. So perhaps you didn't. Perhaps it was the motion of the state. But there is a mechanism in Twitter, or now what's called X, for direct communications, direct messaging. Isn't that correct?
Sure.
Okay.
Yeah, there's
And
also
this-
adding people.
Is an example of how one would use that app to directly communicate with someone should they choose to do so.
It appears if you want to send someone a message similar to an email or a text, you could do so via X or Twitter.
Okay. Were any of these, what you call messages, conveyed in that manner?
I'm sorry, I don't understand your question.
Or was this messaging, this direct messaging used by Mr. Floyd to convey messages to any of these witnesses or co-defendants?
I don't have any evidence of that, no.
Is the answer no?
I don't have any evidence of that.
Okay, so
You may have, I don't have any evidence of that.
okay, so you can't say that they did.
I can't say that he
In
did.
fact, all of the messages and exhibits to which you referred to, that isn't the mechanism by which you contend a message was sent to any of these people, is it?
I'm sorry, I don't understand your question, sir.
Okay. The message, the mechanism by which you say Mr. Floyd communicated with people
Yes,
was by putting the ampersand in front of their tag.
correct.
Isn't that really how you reference people?
Well, in the instance of what we're discussing today, that's how he referenced and how he communicated with people.
Well, I mean, when you reference someone, what does that trigger? What happens? When I put an ampersand in front of someone, do they get an email with the message contained inside?
So one of the witnesses in this case, and I think this will answer your question. One of the witnesses in this case, when I spoke to him about the one of the symbols or when he added them on X, it was conveyed to me that although he did not get the instant notification because he does not have that setting on his cellular device, once he looked at his notifications via his Twitter or X, however you want to reference it, he did see
Right.
all of the ats that Mr. Floyd continuously
I mean, I think that's
utilized.
the point they're trying to make,
Now, I
but it's
noticed
not going
that
to
you-
work.
When you look at Exhibit 12, do you have those exhibits in front of you?
Yes, sir, I do.
Okay.
An ampersand?
This is
No,
referencing,
not the
and
ampersand.
it's reposted, it looks like it's 11 seconds long. What is this? Where did this footage come from?
As I mentioned earlier, this is the body cam footage from the Cobb County Police Department, evidence in this case of Ms. Ruby Freeman at her home.
Well, this is in public domain, isn't it?
Well, can you
These
ask your
videos
question again?
have been released to the public.
Some of these videos I have seen in public articles and news media. I have.
Or are there any of them that you haven't? Or are there
What?
any of these that you could say
What does
are
that
not
mean?
in public domain?
None of the videos that we've observed today. No, sir.
So they're all public domain as far as to your
Ay,
best
ay,
knowledge
ay.
and belief, correct?
Sure.
Okay. And so when
Right?
he posted something on his account
Great lawyering.
referenced it,
Great
it was-
lawyering.
conveying his opinion,
I can't. I think you're asking me to speak to the mind of Mr. or defendant Floyd. I don't know what he was trying to convey.
well, I see here, for instance, on number 12, it states Exhibit 12, where it says an ugly comment by Leonard Fulford. Who's Leonard Fulford?
I wouldn't know. Perhaps defendant Floyd does. I don't know.
Did you ask Mr. Floyd if he knew who he was?
I haven't spoken to you or the defendant in this case.
And so, in other words, as far as you, he may know, but he may not know, correct?
Oh, my Lord
I don't know,
in
sir.
heaven.
Okay,
Sure, Klein.
Well, I understand, but you're complaining about this comment by,
Objection to the characterization. The state of Georgia through District Attorney Willis claims of the conduct of Mr. Floyd that led to harassment of these witnesses, not Assistant Chief Michael Hill. Objection.
All right, so Mr. Morrison, what would be your response to that? Or do you want to rephrase?
I'll rephrase it.
All right.
Why don't?
Specifically on Exhibit 12, there's a comment at the bottom that you were asked to
Exactly.
highlight and to speak on.
Correct.
And it was made by Leonard Fulford.
Okay.
And you have no knowledge that Mr. Floyd had
Okay.
anything to do with that comment, do you?
No knowledge, sir.
Likewise, on the bottom of State's Exhibit
Well, he
13,
prompted it.
there's a Debbie J, which says brunettes are great. Brunettes are great.
Hmm.
Made an ugly, I'll call it an ugly comment.
Yes, sir.
You don't
Would
have
you-
any
would you
information
consider it
or knowledge
ugly?
or belief that Mr. Floyd had
the
anything to
word
do
you
with that
used?
comment being made, do you?
If you're asking me if Mr. Floyd had anything to do with the comment being made, the comment was made under the post of Mr. Floyd. So I would say, if you're asking me, he did have something to do with that comment being made. How else would that comment appear under his post if he hadn't have made it?
Did he make the comment?
Right.
Did he make the ugly comment that you just referred to?
Right.
Apparently it comes from Debbie J at Brunettes Are Great.
Do you know who Debbie J is?
I don't.
Objection asked and answered.
No, that was with regard to Mr. Leonard, I believe.
I don't recall that one. Why don't we get through it? So you can re-ask the question.
Do you know who Debbie J is?
No, sir, I don't.
Okay. Do you know if he knows who she is, Mr. Floyd?
I don't have that information.
Likewise, on Exhibit 14, there's a MSTSH80. Do you know who that is?
No, sir, I don't know who that is.
Do you know if Mr. Floyd knows who that is?
I wouldn't know, sir.
Do you have any information
Is he
that,
gonna just go through everybody's comments?
okay, let's go to
'Cause that's
15.
dumb.
Justine
Oh, he's just going through the ones. Okay, good.
made a comment.
Comment.
Yes, sir.
And do you have any information that Mr. Floyd knows who Justine is?
Same answer. No, I don't.
Or Cindy P on Exhibit 16?
No, sir, I don't. Wait, I might.
I'm sorry, what's the
Or,
question?
or I said, with regard to Exhibit 16, Cindy P.
With regards to Cindy P, does Mr. Floyd knows who she is? I wouldn't know that information.
And for all you know, these are just people who are expressing their opinions based on,
On
his
freedom of
post.
speech.
and he has no control over these people, as far as you know, does he?
It's freedom of speech.
Does he have control over these people? As far as I know, I have no knowledge. No.
Okay, and he has no control over what they say or don't
Well,
say, or what
you
their
know,
comments are,
The
does
good
he?
news is all
I
these
don't have-
lawyers
I
kept
don't know
going
either
on
way.
each other's shows.
I don't know what control
and
he has over
they
these
got it in their
individuals, or
heads
if
that
he
they're
has no
actually
control,
good
or
at
if he does.
arguing these.
Now, I
when they're
noticed
not in real
On one
life.
of your exhibits,
So there's that.
I think maybe it was number 11.
Exposure.
Let me see if I can find it.
It's exposure. Bad lawyering, man. Bad lawyering. Jay Rance! Hello! My lovely BFF. That's the best friend forever.
One moment, Your Honor. I've got these out of order.
Do 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 do. Boop.
I'm specifically looking for the exhibit
Boop boop. Boop 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 boop.
where Mr. Floyd talks about, let me find it, please, Your Honor. One where he says, Black American Dems want the black Trump guy to tell on the racist white Republicans.
Harrison liked
Only
this
if
comment
it's
under that
President
tweet.
Trump.
Turned my
Oh,
stomach
well.
issues at the White House and looked touted a hero.
Are you familiar with, do you have
This
that
comment,
exhibit?
it would turn my stomach. That's the comment.
Can you, I am familiar with that, but I do not have that.
He's like a
Exhibit
really
in front of me,
obvious,
sir.
obviously
They
being a
put it
piece of
in
shit.
its
That's why I'm
motion.
like, I'm
Well,
not
have you read the
buying
state's
whole
motion?
thing.
Yes, sir, I have.
You may.
Let me show you this
Okay.
right here.
Oh, this is the
And I'm gonna
comment.
just label this exhibit C for
It's
you.
terrible. People are terrible. I hope they get a movie. You know what I mean? Like, I hope really good
You
things
recognize
come
this
to them.
post
I know it
here at
won't
the
make
top?
up
Yes,
for
sir, I do.
anything.
I do recognize
I
that.
noticed
But-
that this portion here at the bottom,
Oh, sorry, Jay. I'm sorry. I missed that comment. Yeah, about an hour.
The portion, which portion, right
This is
here?
the first
Yes.
witness, though.
that
of
wasn't in the state's
three.
motion. Could you
First
tell us
witness
what
of
that
three.
said?
Are you asking for this from Brooklyn Flowers?
Yes.
So the comment under Mr. or Defendant Floyd's post, Black American Dems want the Black Trump guy to tell on the racist white Republicans, but only if it's President Trump, LOL. Look, the truth is that at Georgia Secretary of State and at Gabriel Sterling are the pieces of fecal emoji you should be mad at. Make elections fair again, #fraud, #Fulton. And then there's a comment from Brooklyn Flowers that states, you're, in all caps, broke and going to waste more money putting forth this all caps election lie. We can't wait to, all caps, lock you up here in Georgia, as if those 5 days you spent in Fulton jail wasn't enough. And then there's an image that says, warning, coon-fused Negro alert.
Coon spelled C-O-O-N, correct?
Yeah, that's correct.
At the beginning of the fused.
Yeah.
So an intentional misspelling of the word confused.
Yeah, sure.
Are you aware that this is actually what Mr. Floyd is responding to, is a comment? That's not a comment that's in response to his post. That's him posting a response to this message he received. Were you aware of that?
What?
No, I'm not aware of that.
Understand.
I'm not aware of that. Yeah.
I mean, what? I'm confused. Did he just show him that he was responding? I'm very.
No, sir.
Okay. Now, if I look through these comments,
I don't know. Is it? I mean, I defer to the smarter minds in the chat, of which you are one.
he makes a comment, for instance, in Exhibit 19. Makes a comment, he says, why would you keep Jenna Ellis and proper videos when there's better stuff? For instance, Ruby Freeman's job was the reconciliation of ballots. She wasn't even supposed to be on a scanner. You're familiar with that?
Yes, sir.
Okay. Do you contend that has something to do with the allegations against Mr. Floyd?
What?
I'm sorry, what's your,
high.
do I contend that, ask the
That
question.
what has
Him
to do
talking
with-
about what Ms. Freeman's job.
Stipulate that that goes to the facts of the case. If that's what he's looking for, we'll stipulate to it.
No, I believe it doesn't go to the facts of the case.
All right, so the stipulation is rejected. Mr. Morrison, let me ask your question.
Isn't it true that this is just speaking about what her job was or wasn't, and what he could release? In other words, that he didn't release the
Sometimes I get a little
property.
stuck.
Yes, sir, that's correct.
In fact, there's a lot of these where he's talking on the 13th and the 14th about the proffers that were made.
Yeah, right?
And that he's upset that his team has been accused of, or he has been
Yeah.
accused of, quote unquote, leaking these proffers. And he denies it.
Too
Is that
many
true?
dicks on the
Yeah,
dance
sure, that's true.
floor, too
And
many
do you
dicks.
believe that there's anything in the bond conditions that prohibits him from defending his good name?
I wouldn't say that there is.
Now, likewise, I noticed this Exhibit 23 that you put together a couple of days after it was posted.
Yes, sir.
Is she referring to Mr. Floyd's comment about her accepting money for her defense and then really not needing a defense because she entered a plea?
Wait,
One
what?
second. Yes, correct. So
What was
states Exhibit 10. That's
What
what
was the
she's
date of
referring to.
that comment?
The date of the comments
walruses.
was November the 13th, 2023 at 6:49 p.m.
Okay, and this says, I saw it a couple of days after it was posted. What was the date of Exhibit 23?
The
you
date
laughing at?
of Exhibit 23?
Yes,
Yes,
Are you asking,
that's what I said.
she sent, is this a text message in Exhibit
oh,
23?
when was this communication received? Today?
Yes,
Today, this morning.
today.
Yeah, that's what I said earlier, 10:59 a.m.
Okay, I didn't catch that.
Yes, sir.
What the
November
fuck is
21st
this?
today.
I think he's being mean.
And this
Why
is
are you
after
so
you've
fucking
asked
weird,
her
bro?
to text you something. Is that correct?
So I didn't speak with Ms. Ellis. I spoke with her counsel, Mr. Mike Melito. He spoke with his client regarding the post for Mr. Floyd,
Yeah.
dated
the
November the
investigator.
13th.
That's what he does. He investigates.
That was her response regarding her viewing that post. When
That
he
was her
added her.
response to whom?
That was her response to her counsel.
So this is hearsay on hearsay,
It doesn't matter.
correct?
It's allowed.
She spoke to counsel,
just told
counsel
you.
spoke to you, and now you speak to the court.
No, that's not how it.
I mean,
No.
that's typically how it
He's
goes.
the
in
investigator.
Criminal
He's
investigations and folks that
testifying
are
as an
represented by
investigator.
attorneys, you would speak to their counsel to obtain any information that you need from that individual.
Although hearsay, we understand, is admissible in a bond hearing.
Exactly.
This would not be admissible in a regular.
Doesn't matter.
proceeding.
We're not there yet, baby. Don't worry.
Mr. Morrison, I think you made your point. Let's
Thank
keep going.
I'm the one you need to convince. So let's move on.
Isn't it true that none of
Isn't
Mr.
it
Floyd's
true?
posts contain any threats of violence?
Isn't it true?
No, I wouldn't say that any of his direct comments contained any threats of violence.
Okay. Is there anything in his comments that show he's trying to get witnesses that he's trying to collude with witnesses to change or alter their testimony?
Yes.
I believe you're asking me
entire
to
case.
somehow enter the mind of defendant Floyd and figure out what he's trying to do.
No, I'm asking you about the content of the
Kind of
post.
like
Is there
Right.
anything in there that you see?
Right.
That indicates he is, if you were one of these people?
So my response to that is I believe you're trying to ask me about the mind of defendant Floyd and what he's
No.
trying to do. And my response to that is I can't tell you what he's trying to do to these individuals that have been identified as witnesses in the case, but I can tell you that he is certainly communicating with these individuals and, what effect that may have upon their testimony, what effect that may have upon them feeling harassed, threatened, or intimidated, I believe is up to those individuals. And that, as you saw in State's Exhibit 23, that's how witness Jenna Ellis felt by virtue of Mr. Floyd's communications to her.
Well, you're the one who solicited this response from Mrs. Ellis, correct? I mean, she didn't reach out to you and say, hey, I saw this communication and I feel intimidated, did she?
No, she
To
didn't.
the microphone.
But I would imagine she may reach out
He's
to
he's
maybe
the
law enforcement
investigator.
and where she resides or something of that nature. But
I'm not asking you.
but no, she
He's the
didn't. Yeah, she didn't reach
investigator.
out to me to tell me that she felt threatened
So
or
he was
harassed or intimidated.
investigating.
This was her response when asked.
Understand, and you've
As
not
part
received
of
any communications from anyone else
His
that
investigation.
you brought to this court showing that anyone was
I mean,
intimidated or
I'm
felt
pretty high
harassed
and I'm not very
or
smart, but
and
I
pushed to collude or change
I
their
don't think
testimony.
this is
Has-
going anywhere.
I believe the other witnesses that are testified today may be able to speak to that.
Okay. Well, I'm asking you.
Well, you just said you don't want
Have
my
I received
opinion.
any other information about witnesses feeling intimidated or harassed? Is that the question?
I'll move on. Let's see.
I'm not making any sense. Let's move on. Wait, I don't know where to move to. Oh, that is my laundry list. Oh, damn it. Okay, wrong folder. Here we go.
At any point in time,
Let's make sure.
were you asked to contact any of the attorneys on Mr. Floyd's defense team and say, look, he's making posts that we don't
Is
like?
that appropriate?
No, sir, I was not asked.
Were you aware of anyone who thought that they were a problem and they needed to
That's
be
why we're here,
addressed
sir.
and sought to address
That
them
is
with
why we're here, sir.
his defense team?
That is why we're
Was
here,
I aware
sir.
of anyone that, I'm sorry, ask that question again? I'm
Yes,
sorry. I didn't
sure.
understand.
I mean, here's the thing.
Did he
These
stop after he
comments
got
that have been
served?
brought before
Did he
the court,
stop
Yes,
after he got
at any
served?
time were they brought to the attention
Did he
of
stop?
Mr. Floyd or his
after he
defense
got
team and
served?
said, look, there's a problem here?
Did he
Mr. Floyd
post
made the
after he
comment,
got
so
served?
he was very much aware of the comments being made.
My question is there anyone
I'm
who
not-
made
no, he's
his
free on
defense team
bond.
or him
No,
aware
he
that
had to post bond
these comments were a problem in the eyes of the state?
because of the altercation with FBI.
I'm not aware of
agents.
anyone that reached out to you to say, hey,
Or
this
that's
is a
what the story
problem.
was.
That's
I
your
don't know.
question.
Right, or to anyone else on the defense team.
No, sir, not that I'm aware of.
Did he post after he was served? Did he post after they filed the motion to revoke bond? Did he post
And
after
in none
they
of,
filed
in
the motion?
any of these
Sorry,
comments, he never asked for a
Really high.
response from anyone, did he?
Why? That's not his job. That's not his job. Exactly. I mean, that's not his job. Is not to go around
So in
to
State's
the
Exhibit
target
number
of the
6,
investigation.
this is
He's
to
not
answer your
necessarily
question.
allowed to
Mr.
just
Floyd
do
says,
that.
passing this along to Georgia Secretary of State and Gabriel Sterling. So he's addressing them. He's communicating with them. And then he asks the question, should they be more concerned about interfering in elections, perjury before Congress, lying to DA Fonnie Willis, or all the above? And so
He
you're
gets,
asking, is
put
he
in
asking
jail
something of someone?
if
He's
this
asking a
doesn't work
question
out
there,
in
but
his
again, I'm
favor.
not in the mind of Mr. Floyd, so I don't know if he's
Pre-trial. He's
asking
held
that question
pre-trial.
to
He did
them
sign the
or
bond.
if he's just posing
This
a
is why I
question.
think
I
it's
just
a
know that he's
game.
communicating with these individuals.
I think this is
and
all a
he's making
game,
these
and he knows
comments.
how it's going to end, and he thinks there's a payday on the
Yes,
other
sir.
side because
In
somebody
fact,
convinced
when I
him
asked
there's
you
a
this question
payday on the
earlier,
other
Sure.
side.
He's referencing these. When you put the
MAGA
ampersand in
believe
front of
really
someone's
incredible
handle,
things.
that's a reference to that person so that other viewers may know who you're talking about, right? As opposed to sending a direct message.
So
Now
perhaps
do
I should
it for
answer it this way.
everybody, please.
I disagree
That's
with
what
you
want.
in
I
your
want equal
categorization of that.
treatment.
He's
That's what I
communicating
want.
with these folks individually. And the way that I know that is that Mr. Gabriel Sterling, in fact, stated that when he was added, when that communication was made by Mr. Floyd, when he opened his cellular device, he went into his X app, or formerly known as Twitter, and he viewed all of the ads that came from Mr. Floyd. So in my mind, and I believe in my mind, that's communicating with.
So when someone has the ampersand
I
put in front
know
of their
every time
candle,
someone
it
asks,
simply sends them a notice that there is,
unless
that
it's
they were
live,
referenced,
which most
correct?
of the time they are.
Mr. Sterling was put on notice by Mr. Floyd, defendant Floyd, that he's communicated with him or he's added him. He's made a comment about him.
or that he's referenced him.
You can say that too,
Because
but I categorize it as communicating with.
often
No,
using
the
the
lawyer's a
ampersand
moron. You're so right.
is a way of
Lisa.
referencing people for others to know who you're talking about. And to likewise let someone know that you
Darlene,
talked
please
about
stand at the podium.
Objection asked and answered.
All right, and I also think I'll cover this after we're done with Mr. Hill, but I do think we're covering things that could very well be taken care of through argument or proffer.
Right.
And in the interest of finishing today, I think we should refocus on that.
That's
Yes,
right.
sure. Willie Lewis,
His parents could be
referenced
blamed
Willie
if he were a
Lewis.
minor. That's
you
right.
know who Willie Lewis is?
But
Willie
he's
Lewis
gonna be
Floyd
blamed
III is
because he's an
a,
adult.
an alias for Mr. Harrison Floyd.
You're not aware that that's his father.
You know, I did see another Willie Lewis Floyd that does not have the third at the end, and I always thought that was his father. So you just confirmed that for me. Yeah,
Ah!
I thought that was his dad.
So,
Oh!
so when you say that
Oh!
Willie Lewis III is Mr. Floyd, you
Oh!
may have been incorrect, correct?
No, I'm absolutely correct because I'm talking about Willie Lewis III. That's also the name on Mr. Floyd's, defendant Floyd's North Carolina driver's license, I believe.
Oh!
Did anyone from the Secretary of State
Oh!
or Mr. Sterling contact your office at the time these posts were made?
Oh!
No, sir, not that I'm aware of.
Thank you.
Redirect, Your Honor.
Holy fucking hell! So holy! I
think
love
we're gonna
these
start
people
at the
so
end.
much.
One of the questions
I
on
love this
cross-examination
witness so
was, did the defendant communicate with, did he ask for responses from, people?
Look at him. He's like, I need to just go.
I'm handing you again
need
what's
to
marked
poop.
as State's Exhibit number 12, and for brevity's
Everybody's
sake,
pooping.
the last sentence by Mr. Floyd in State's
Everybody's
Exhibit
pooping.
12, what does it say?
The last
Everybody's
sentence states,
pooping.
I'll wait for you to get your emoji popcorn.
Okay.
Ooh,
And then also
everybody's pooping.
here in State's Exhibit number 8, in the, we'll call
Look
it the
at that
second
defense
sentence here,
lawyer.
does he
is
request a
pooping
response?
after
What does he state?
Look, the truth is that at Georgia Secretary of State and at Gabriel Sterling are the pieces of
this
poop
is how we
you should
do
be
it.
mad at.
how they should feel, correct?
Correct.
pieces of
Also, I want
poop.
to correct the record. I'm marking as State's Exhibit 27, the defense's motion, and specifically page 27 of the defense's motion that they filed.
Wow.
Is State's Exhibit 27 would already be part of the court's
RCTV.
record at number,
Right.
page number 7. I'm gonna ask that it
Without
be
objection.
admitted at this time. I'm sorry?
That's an objection.
Without objection, Your Honor.
Oh, without
Thank you.
objection. Okay.
The defense attorney asked you when you were on cross-examination how these posts came, and there was, I would call it a racial epithet against Mr. Floyd.
That's
But
correct.
he asked you, how did it come? Was it not in direct response to Mr. Floyd's post? Was the comment that came that he referenced, was it in direct response to Mr. Floyd's post? When you're now looking at it as it is displayed by the defendant in the defendant's motion?
Yes, yes,
Your Honor,
that's correct.
I'm now showing you what I've recently marked as State's Exhibit number 26. State's Exhibit number 26 is the actual bond, consent bond order in this case. Do you recognize it to be that?
I do, ma'am.
Is it
Stipulated.
part of the court? They'll stipulate it. I'm asking that it be admitted. I'd like you to read into the court record what provision number 5 says.
Provision number 5 reads, the defendant shall perform no act to intimidate any person known to him to be a co-defendant or witness in this case, or to otherwise obstruct the administration of justice.
What was the status of Janice Ellis?
I don't
She
know.
was, initially, she was one of the
Can't wait.
19 defendants in this case, and she is now a state's witness.
Okay, so she was initially a co-defendant, correct?
Correct.
What is the status of Gabriel Sterling in this case?
He is a witness in this case.
And Miss Ruby Freeman being listed 40 times, what in fact is her status?
She is a witness.
All right. Number 6, can you please read into the record, first of all, the whole provision of provision 6?
Provision 6, the
I'm
defendant.
sorry to interject. The document speaks for itself. I mean,
Well, Your Honor, I would ask that he had him on direct. I now have him on, on cross. I would like to make some brief points.
she has redirect, I can understand, but I mean, for him to sit here.
No,
and read the order-
I take your point, Mr. Kaczmarov. If we could just refrain from reading things that are already part of the record, and if there's an additional follow-up, we'll just get to that part.
Okay. Well, I'm going to ask you to
Well.
state number 6 because I want to point out some words in number 6. So if you'll read it in its context, and then if you'll tell the court 1, 2, 3, 4, 5, 6, 7, 8, 10, 11. What is the 11th word? Please read number 6 and then tell me what the 11th word in provision number 6 is.
Okay, so the provision is the defendant shall not communicate in any way, directly or indirectly, about the facts of this case with any person known to him or her to be a co-defendant in this case,
Remember that thing
except
you
through his-
signed? Remember
his
that
or
thing
her
you
counsel.
signed?
and the numbered word that you wanted to emphasize was indirectly.
Remember that thing you
Indirectly, correct.
signed?
Okay, let's read number 7. Can you please read paragraph number 7?
Oh, they are magical.
Also word number 11. Can you read the whole thing?
Yes, ma'am. So 7, the defendant shall not communicate in any way, directly or indirectly, about the facts of this case with any person known to him or her to be a witness in this case, except through his or her counsel. And the word that you emphasized was indirectly.
And is this bond order in fact entered with Harrison William Prescott Floyd
That's correct.
and signed and agreed to upon
Here
by
is
both the state and
thing
defense
you
counsel?
signed.
That's correct.
Who signed
Here's
this
that
order?
thing you
Counsel for the defendant,
And who signed the order from the
court?
the Honorable Scott McAfee.
You signed it. Your lawyer
You have
signed
an
it.
opportunity to
You all
review
signed
how many times the posts against Ruby Freeman were viewed.
Yes, I did.
How many?
Nearly 500,000 times. I think the approximate number is 466,000.
And in your investigations, have you had the opportunity?
Lord, I hope it was
Beyond the scope of the record in cross-examination.
Oh, I hope it was worth
And the line of questioning is the reach of these posts, is it right? All right. We can open up that line. I think it's relevant.
And in investigations, I know you said you did not personally have a social media due to your line of work, but have you had the opportunity to investigate social media posts?
Yes.
And is it the culture of social media when one post people respond.
That's correct.
One moment, Your Honor.
Mr. Floyd, I hope it was worth it.
Nothing further from the state.
All right, recross.
So you researched Ruby Freeman's Twitter account, is that correct? Or X account? Is that what you're saying?
Miss Ruby Freeman, I'm not aware if she has an X account. I don't believe she does.
So she didn't even have an account on this social media platform?
Not that I'm aware of, sir.
Okay. And you said her name was referenced how many times?
No, sir. The question was how many times was the post in which Mr. Defendant Floyd references Miss Ruby Freeman? How many views did those posts
Right. Do you know what
obtain?
it was, sir?
And the answer to that is nearly 5,466,000.
Okay.
That's the answer to that.
And likewise, Jen Ellis has how many followers?
1 million, I believe.
Over 1 million, correct?
Yeah.
Now you said that
What's
Gabriel
the point?
Sterling's going to be a witness, as well as Ruby Freeman.
Okay. Where are we going, sir?
Yes, sir. They're on the witness list.
Where
Yes,
are we going, sir?
Witness list?
yes, sir.
Where are we
Have
going,
you
sir?
turned over that witness list to us?
What?
I'm not sure of that. I believe you should have that witness list. I'm not sure of that.
Would you be surprised to learn that we don't have a witness list?
Oh my
Yeah,
God.
I'd be surprised to know that.
Okay. And likewise,
Bonnie's just like, let me let him get it out.
one moment.
She's like, let me let him get it out and then I'll stand up because I'm not going to stand up multiple times. I know that's where this is going. I know she's like, I'm just going to let him hang himself here a little bit and then I'll.
Where did you get that
swoop in.
500,000 figure from?
Simple math. Just looked at the viewership from each post that Mr. Floyd references Ms. Ruby Freeman. There's a little number at the bottom.
And it's higher by now.
For example,
How about that? Let me blow your mind. It's even higher now.
if you look, let's just look at State's Exhibit number 6. If you look at the bottom, it'll have the number of views. And so if you just simply look at all the posts in which Mr. Floyd references Miss Ruby Freeman, there's several thousand views on many of those posts. And when you add them all up, when you calculate them, it adds up to about approximately 466.
And that depends on when you copied it, correct?
Say again, sir?
Does that depend on when you copied it?
When you say copy, do you mean
Sir,
Right,
when it was
arguing
viewed,
that
when I
the
last saw the
viewership
number?
is
Yes.
smaller
Oh, yeah, I'm
than
sure
that
it's
by
probably
now?
more now.
Okay.
Is that,
And in fact,
sir?
this whole motion brought by the state and the attention drawn to Mr. Floyd may have amplified every one of those
Oh
views
my
of those posts, correct?
God.
Possible. I mean, I wouldn't know the answer. Possible.
Understand?
Oh my God.
Your Honor, just very briefly, if I may.
All right, very briefly.
We've already admitted into the record 27, which is part of the record anyway, the bond motion. I'm on page 3 of the defense's motion at the second paragraph. 1, 2, 3, 4, 5, 6. Review that to yourself. And will you state what word does the defense refer to Ms. Freeman as?
So in this document, Defendant Floyd's counsel refers to Miss Ruby Freeman at that line as a favorable witness. She is a favorable witness.
They recognize in their own motion, although they claim they're not witnesses, that she is in fact a witness.
Judge, we never said she wasn't a witness. Sorry.
What?
I think that's accurate. I'm not sure
Right.
what the point is here,
Yeah.
where we're going with. but
Thank you. Finally.
As well, what's our next point? here?
Sorry.
What's our next line?
What's the
I think
next
we're here.
line?
In page 8,
Where are we going?
how do they
Anybody?
refer to Ms. Jenna Ellis?
Ms. Jenna Ellis is referred to as a witness. Now
So
a
they
witness.
acknowledge them as witnesses, correct?
That's correct.
That's it, Your Honor.
All right, Mr. Hill, thank you. Investigator Hill,
did
just to
know
clean up the record.
Everybody.
I think State tendered a exhibit
Just
20.
stop.
Obviously, we got State's exhibits 1 through 21 that were admitted. Then there was a 23, which was Ms. Ellis's response. I don't know if that was formally admitted. Was there a 22?
There is going to be a 22. It was pre-marked, so not at this time.
Were there other State's exhibits tendered?
26 and 27.
26, all right. And those were, I think, admitted without objection, if I
Your
recall.
Honor, since I referenced an exhibit B and C, does the
The state has no objection to that.
I mean, I think one of them was just the response, which is already in the record. I don't think,
number B, letter B, exhibit B, Your Honor, is an exhibit which specifically shows, I'll grab it here.
okay. And so if we'll just need digital copies of those provided, and we'll have those for the court reporter.
Now,
Okay.
just to make sure the court has.
Sure. Just a moment before we do that, I just wanted to inquire, just so we are staying on track here. I know the state had mentioned there are 2 more witnesses. Would the defense intend to call any witnesses today?
I don't know yet, Judge. I want to see what they have put on.
Okay, but there's a possibility that 1, 2, what is the
Possibility.
ceiling of defense
What's
witnesses
the
that could possibly be
ceiling?
called? Okay, thank you. So potentially we have 3 more witnesses to get through, and we took about, 2 from the state and 1 from the defense. And we've got an hour and a half that we just spent on the first one. So in order for us to finish today, which is the goal, I think there were a lot of things there throughout that first direct that maybe would be more appropriate for a jury. And I'll just note that I'm very familiar with the record and I've read the
You need to
responses.
manage the
And I don't need quite as much
questioning.
hand-holding. So there's a lot that I think could just be argued and proffered. And if there's an objection to the proffer, you can make that objection. But in terms of how Twitter works or what the bond order says or who signed it, I promise you that I know that. So with that, I would ask, and I might be a little more willing to step in here if we can't stick to that. It's taking calls next witness.
Thank you.
Well, Your Honor, we don't expect either of these to be as long.
All right.
We shall call at this time, Mr. Gabriel Sterling.
Gabriel Sterling. Oh yeah, you don't think it's going to be as long? Is that really something you think is not? You think that? Exactly, Judge. And I love you, Judge, but do your job. That's unfortunately on you. You got to do that. You got to manage. You got to manage those lawyers, or else they'll get away with everything, including murder. Maybe not. Maybe not murder. Maybe not murder. Murder. Murder, 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 murder. Sorry. Murder. Get away with murder. Has Judge Rowland taught us? See, this is the thing. We're spoiled. We're very spoiled. If you watch Judge Rowland oversee the discipline hearing for John Eastman, you know judging when you see it. Oh, lordy, lordy. Look who's 40. She did not take any fucks
You get a question truth.
in that fucking
Oh my God.
hearing. It was beautiful.
Spade,
Beautiful.
Robert Gabriel Sterling, RobertGabriel
I know someone who went to high school
Sterling.
with him.
Good afternoon, Mr. Sterling. Where are you employed?
The Office of Georgia Secretary of State.
All right. And have you had an opportunity did you have an opportunity to testify at the special purpose grand jury?
Yes,
in the
ma'am.
matter that brings us here today?
Yes, ma'am.
I'm going to show you a couple of exhibits that have already been admitted into evidence. I'll ask you some very brief questions on them. Are you familiar with State's Exhibit number 2?
Yes, ma'am.
Okay, and just for purposes of the record, if someone tags you at gabrielsterling.org, do you in fact receive those? If they tag you here, then I'll go back and ask about that.
GabrielSterling.org is my old website. I think you're asking
I'm
about
sorry,
my-
at Gabriel Sterling, yes.
Yes.
And also, if someone tags at Georgia Secretary of State, is that
Please
something
make me
that a member of the
sneeze.
Secretary of State's office, to include you, would receive?
Yes, ma'am.
Okay.
Sneeze.
And moving on to State's Exhibit number 7, have you in fact seen this post? State's Exhibit number 7.
Yes, ma'am.
And is that because you were tagged at Gabriel Sterling?
Yes, ma'am.
Moving on to State's Exhibit number 9. Are you familiar with State's Exhibit 9?
Yes, ma'am.
And is that because it was tagged at Georgia Secretary of State?
Yes, ma'am.
Is that what allowed are these tags what allowed these messages to communicate with you?
When you're tagged, it shows up in your feed of items that mention you. So yes.
Okay, and then finally, the last one, State's Exhibit
Give
number 8.
notifications on,
Are
might
you
get an
familiar
email,
with
I
State's
guess.
Exhibit number
I don't know.
8?
I'm not sure.
Yes, ma'am.
And is that again because you were tagged both at Georgia Secretary of State and at Gabriel Sterling?
Yes, ma'am.
Do you enjoy being called a piece of fecal matter?
No, ma'am.
There's so many jokes, but I'm not gonna make them.
Are you a witness in this matter?
Yes, ma'am.
Look at, what is he standing up for?
My witness?
Yes.
Thank you.
My witness, let me go.
Mr. Sterling, you're not a fan of Donald Trump, are you?
Oh, for fuck's
Objection,
sake.
relevance.
Goes to bias.
Bias.
Bias against Mr.
Ooh.
Floyd. All right. We'll give you a little leeway on this.
There,
Got
well,
thrown.
that's true.
You know Mr. Floyd is a Trump supporter, don't you?
Yes.
By the way, the state reached out to
Bill?
you about these posts,
That's
didn't
really
they?
the question,
Yes,
Your
sir.
Honor.
And they asked you to come in and testify about this.
They subpoenaed me, yes.
Is
They
this
subpoenaed you
the-
to come here.
Is this the best they have?
These posts aren't threatening to you. They may not be nice, but they're not threatening and intimidating to you, are they?
It's par for the course when you're in a public figure.
So you are a public figure.
Yes, sir.
When you're tagged, the ampersand you said shows up in your feed.
Yes, sir.
That is a mention of who you are, correct?
The way it works, essentially, when you go to your, for people who don't know Twitter or X,
By the way,
you'll have notification in the bottom part saying if there's a little bell, basically, if something mentioned your name or anything that you follow, you'll have a little red number in there to show you new things that have happened since the last time you were there. And then you would go to that and you would see things where you were tagged in. Yes, sir.
Okay. I don't know if you have State's Exhibit 7 in front of you.
I have nothing in front of me, sir.
Your Honor, may I approach briefly? Showing
No.
you State 7.
as long as you don't punch him.
Where Mr. Floyd says, we want the truth. It's accountability time, unseal the ballots. Are you aware of other cases where ballots are sealed?
There is a matter in Fulton County, yes, sir. It's actually being done in front of a Henry County judge, if memory serves.
So that post could be talking about that case,
I don't know what Mr. Floyd said, sir.
right? We don't know what case this is referring to, do we?
Not particularly, no, sir.
Exactly.
Okay.
Yes,
There's
sir.
a lot.
Are you also, you have approximately 67,000 followers on your account?
70,600.
70,600.
Would you consider
How many
yourself
direct messages do you get a day?
an influencer?
It varies.
Rough estimate?
I do more like the week. I get 3 or 4 a week, maybe, depending. Like right now, I'm going back and
Really?
forth with a gentleman about something going on in licensing.
Okay. And then how many times a day are you tagged on posts?
I have no way of knowing that, sir.
A lot.
It's common, yes, sir.
And it's common that you might miss. You're not paying attention to your notification section every
What is
single
your
post that
point,
goes
sir?
through there, are you?
You missed
When I'm
all of
tagged,
the
I generally go
threats
take
that
a
are
look at it,
coming
yes, sir.
your
But I
way.
mean, it's not so overwhelming that I can't, but I don't look at it every day or every hour now.
And if you were threatened or intimidated, would you contact law enforcement?
If I thought something rose to that level, I would contact law enforcement.
And you didn't contact law
I know,
enforcement in this
but
case?
You're so right.
No, sir.
This is
Your Honor, I have nothing further.
Let me redirect.
Wow, this is
Okay. All right.
this is gonna
Thank you,
go
Mr.
quick.
Sterling.
Thank you.
Can this witness be excused from his subpoena?
Your Honor, at this time, we'll call
Okay,
Bond
so,
Du Bois.
I'm sorry. Can
Bond Du Bois.
you spell that for the record?
D-U-B-O-S-E, but we're gonna let him spell it as well, just to
Okay.
make sure the state got it right.
All right.
This is our final witness.
Oopsie. Things, I'm dropping things. I'm dropping everything.
Madam Prosecutor, who is the next witness?
Bond Du Bois.
Bond?
Mhm.
Is that law enforcement?
Us.
Is that a witness? Thank you.
From this
Hey,
hearing.
Summer, how are you? Good to see you. Doing good stuff. You are Everyone hit the like. Thank you, my love. So good to see you. Doing good work for Breonna Taylor's memory. Thank you for everything you do.
Well, for testimony today will be the truth, the whole truth.
I do.
Can you spell your name for the court?
My name is Vaughn Dubose, VONDUBOSE.
And Mr. DeBose, will you please tell the for purposes of the record, would you state what your profession is?
I'm an attorney.
And do you in fact practice in this jurisdiction as well as others?
Yes,
Do you have a client that is a witness in this case?
I do.
Can you please state for purposes of the record what your client's name is?
Ruby Freeman.
Oh, I'm sorry.
I am going to hand you
Wow, that is going to be busy.
what has been marked as State's Exhibit
Good energy
number
your way.
22. Tell me what State's Exhibit number 22 represents.
Yes, I can.
Prevail.
Can you
Of
tell
course.
us, please?
You got it.
Yes, it's a
Anytime,
threat
my
level
love,
report.
anytime.
That
Anytime
we
I
have
can,
a
I
third-party
will.
vendor who will monitor online activity regarding potential threats for Ms. Freeman and her daughter and their family.
Why do you have a threat monitoring report that relates to Ms. Freeman and her daughter? And what is her daughter's
I
name
know,
for purposes of the
spell
record?
check.
Her daughter is Shay Moss.
I got it.
You
I
also represent
understand.
Ms. Moss?
I do.
Is Ms. Moss a witness in this matter?
Yes, to my understanding.
And in fact, have you accompanied them to proceedings in this matter?
I have.
Why did you hire this company to do threat assessment on your two clients? Is that something you do for every client you have?
No.
Why did you find it necessary to do for this particular client?
Well, just the level of threats since all of this began for Ruby and Shay have been quite high. She's been listed on death lists. She's been told that she needs to leave her house by the FBI. So we just need to keep an eye on what's out there, whether there are any spikes or flashes in the threat level. So this company
Boy, this
has
better
been
have
retained to do
worth
that.
it.
And in fact, the threat levels at one point prior to this matter were so high, she had to
Here,
relocate from her
Summer,
home.
but I did
Absolutely.
testify against the sex crime units last
and
week.
that was on
our case. That's
recommendations of the FBI.
fantastic.
Yes, it was.
Congratulations. Oh, congratulations.
Prior to the state
And police
Contacting
corruption. Fuck 12.
were you made aware of some comments by a defendant in this case on social media?
Yes, I was.
What defendant were you aware of making comments as it related to your client, Ms. Freeman,
Right.
prior to the state ever contacting you?
Mr. Harrison Floyd.
How is it that you became aware that Mr. Floyd, the defendant in this matter, was making comments about your client?
Well, a couple of my co-counsel informed me that there were some comments being made and that we needed to huddle together and have a session to assess what was going on and to determine whether there were any measures that needed to be taken by us or by Ms. Freeman and Ms. Moss.
To keep them safe.
To keep them safe, absolutely.
And in fact, as a result of these comments made by Mr. Floyd in relationship to this matter, did you call what you referred to me as a spike?
Yes.
Can you educate the court as you educated me as to what a spike is and why that may cause you some concern as well as the other team that represents her?
Sure. So a spike is simply a time at which online activity regarding Ms. Freeman
Somebody
and her
did
name
look
is
at the
mentioned
correlation.
at a particular
Oopsie,
time, and you can
oopsie.
tie spikes in this report to actual posts and things of that nature. So I believe this is the
Court just
report
never
that
quite
tied
turns out like MAGA
a particular
think it's
spike
going
in
to.
online
You know?
activity
Have you
to
found that?
the tweets from Mr. Floyd.
Pretty,
And traditionally,
pretty established
as these things
pattern.
go in this case and with Ms. Freeman, this is the beginning of potential threats. So that got our attention. We were very concerned about that, and we wanted to make sure we addressed it appropriately.
And so
think that
I don't want
their
you to get into security precautions you took, but
communications
were
are
in
there,
fact
they
some
can
precautions
act like
taken
they
as a
do when
result
they're
of
in
this?
their
Yes.
right-wing echo chambers,
moment.
and now they're finding out that they can't act like that.
No further questions. Your Honor, at this time,
I
I'd
know,
ask for
I'm not
Exhibit
sure.
22
if
be
it-
admitted
yeah,
into evidence.
exactly. I
Subject to cross-
understand this. I understand this.
It's
It's
Exhibit
touchy,
22.
yeah.
You need to clarify some things before its entry. All right. Well, let's start with
Although
that.
maybe this sets the precedent to execute on other people. That's what I'm hoping.
This is the
Don't let it
report
be
that you had.
unfair
together.
or a sideshow. Let it be
The
fairly
report is
applied
generated periodically.
across.
Who is Protect Democracy?
Protect Democracy is a not-for-profit.
And so they're the ones that are generating this report?
No.
Nope.
Why are they on here? Are you Jensen Hughes? Is that your firm?
No. Oh,
Why is Protect Democracy here for the date of November 15th, 2023?
Protect Democracy is counsel to Ms. Freeman, Ms. Moss.
Are there
Oh.
also an attorney?
Yes.
Okay, I'm sorry. I didn't know. Just asking.
oh my God.
So
Do
this
you
isn't
do any
this
work?
report, all
Do you
those
actually
pages.
do any
This
preparation,
isn't
counsel?
all just Harrison
Hi,
Floyd, is it?
Max. How are
That's
you?
wonderful.
Welcome.
Right. It's other
Good to
people like
see
the
you.
Gateway Pundit, correct?
I think they mentioned, yeah.
All these posts, all these videos, they're in the public domain, are they not?
And your point?
What posts?
What's your point?
These videos of Miss Freeman at the Cobb County station.
Are you
I don't know if all of them
Are
are
you
or
kidding
not.
me?
I can't
Do you
say.
you have no idea whether these things are in the public domain already?
When you say these things, what are you referring to?
yeah.
Oh, I'm sorry. Miss Ruby Freeman's videos of her in the Cobb County police station being on body cam
Being threatened?
that night of
You want
January
to finish
the
that one?
4th
You
or
wanna finish
5th,
that?
2021.
Okay. And I'm having
There
trouble
you go.
kind of understanding which particular videos you're talking about.
Right.
It's hard
All
if
the
I don't
Cobb
have
County-
them in front of me.
You
But
can't
the
say
Cobb
that.
County police
All the
videos.
no, this is bad
don't know that
lawyering
for
right
sure.
now.
I don't know if they're all in the public domain.
You're her attorney, right?
Yes.
Charged with protecting her?
What?
Sorry?
Charged
Sir?
with protecting her?
I'm charged with representing her as counsel.
Excuse
So you're
me?
representing her as counsel and you haven't researched what's out in the public domain about her?
That's not accurate.
Well, you don't know whether any of the
Oh my God, he has
Cobb
those
County
glasses
videos.
that click in the middle.
are in the public domain, right?
That's not
All right.
Objection.
accurate.
And also, Mr. Kasharov, I think the focus here was supposed to be the admissibility of State's Exhibit 22. That's the
Yeah, okay, I'm
pending
sorry,
question.
Judge.
So,
So this also
So why don't
includes
you
other
get
people
to it, you
apart
stupid
from
piece of
Harrison
crap?
Floyd, does it not?
You stupid
Like
poop
the Gateway
emoji.
Pundit.
You stupid fecal matter
Stipulate
emoji.
that he is correct, that it is.
I hate that
All right.
fecal
And
matter
again, I think
emoji
you're
is the
getting
motif
into
that's coming out of this
argument
one.
concerning the document,
We
not
need to-
necessarily its
We
authenticity.
need to switch
I'm
that.
not going to authenticity, but actually to relevance because they're putting this in for stats in the spike, but they've included not just Harrison Floyd, but influencers on social media that have millions of followers.
And I
Okay.
think that goes to its weight, not its admissibility. So I'll admit 22 over objection, and you can go from there.
Yeah,
Okay.
there you go. How about that? Move on, counselor. Click those glasses, babe.
Miss Ruby's address is private, correct?
Yes.
Phone number is private,
Oh
correct?
my God.
When you say private, do you mean,
It's not out in public.
well, her address has been out in public, her previous address.
And have you spoken to her in the past few days
Yes.
about this issue?
Yes.
And did she call the police about this issue?
No.
Why not? And my question to the counselor would be, do you think she should? Are you telling me she should? Is that what you're trying to say?
Miss
counselor?
Freeman also has a lawsuit against the Gateway Pundit, does she not?
That's correct.
And so this report was generated for that lawsuit?
I don't know. Who cares? Does it matter?
Nothing in the post that you've seen constitutes a threat under Georgia law, does it?
Which post are you talking about?
Yeah, you have to be specific.
Post that the state
bitch.
showed you about Miss Freeman
Nope,
today.
you got it. No,
You're gonna have to show me
You
what
have
law
to
you're
show.
talking about. I'm not quite sure what
You
you
can't-
mean when you said
I
threat
love
under
lawyer
Georgia.
on lawyer.
You're an attorney,
Lawyer
right?
on lawyer
Civil
action
attorney.
is so
Civil
hot.
attorney, but you know what it means to say
I
threats, don't
love
you?
it.
I'm very particular about Georgia law.
So you don't know what a threat is.
Sir,
Ask and answer.
don't be
Overruled, I don't think
disrespectful.
we've gotten an answer yet.
What's the question?
You know what a
Yeah.
threat is?
I do.
There's nothing in his posts that are threatening, is there?
No, I disagree.
There's nothing in those posts that are intimidating to a reasonable person, are they?
I disagree.
Disagree.
I'm not talking about the follow-up post. I'm talking about
Don't
Mr.
care.
Harrison Floyd's
I
post.
disagree.
I am too.
Ah! Oh my God. I'm just like, this is like porn. This is my porn.
The threat level on these this report doesn't show that the spike came from
Yeah.
Harrison Floyd, does it?
It does.
I may
It shows
watch
that the
this
spike came
again.
from a conglomeration of sources. You read the report?
Oh my god!
I have.
Hi, Joanna. How are you?
Judge, I have nothing
He's a
further.
Smart ass. That's terrible.
You redirect.
Questions for this witness from the state?
Poorly
Okay, thank you, Mr.
prepared.
Boyce.
Thank you, Judge.
That concludes
Yeah,
witnesses
exactly.
for the state, and we do have some
If
argument
they
we'd
were
like to make.
actually
Of course, Ms.
intimidated into
Willis.
silence,
Any
then
evidence on behalf
was
of the
there
defense?
really a
No, Your Honor, we
problem?
don't need.
Wait a minute.
Okay.
I know.
Yeah, hang on a minute.
Sympathetic lawyer on the stand. Yeah. Oh, this is amazing.
we need to break it all?
Harrison Floyd, you're gonna
5 minute break
get.
would be nice, too.
Boop,
Let's do that.
boop, boop. Let's do a break.
May I have access to the ladies' room that's there, please?
Yes, please. Give the woman what she needs.
The jury room, or you saying she wants to go back?
Okay, wait. I'm gonna pull up while we're doing this. I'm gonna.
You want to go to the jury room? Or you want to
Yes, that's fine.
Jury room. Is that a good idea? God, I don't know. Okay, here we go. Are they just doing like? Are we gonna go off the record or anything, or what are we doing here? Okay. Well, all right. Here we go. Let's do this because we have. This is not what I wanted. Oh shoot! Hold on. I gotta find the other thing. Hold on. Dag nabbit. Dag nabbit. Oh, here we go. This is the thing that hold on. That was one of the videos that Hootie Pop, what's his name, was caught in. Hold on, there we go. All right, here we go. Let's make this a little quieter. Okay, this is the thing where join Ash in America. Ash in America is an idiot that is part of the Lindell con. So I can only imagine. All right, here we go. Rumble? No thanks. Okay, here we go. Oh, well, we're not watching the whole thing. Was there a clip in it? Oh, wait, let's find it. Okay, we'll find it. Do-do-do. Oh, here he is. Here we go.
Floyd, Fulton County persecuted, numero uno. How are you doing, sir? Well, first and foremost, I want to start out by saying happy birthday. Friday was the Marine Corps birthday, so it's a little belated, but
So this
you know,
is
it is what it is. You
recently.
were a Marine, served. You served in Iraq and Afghanistan, or were you just Iraq?
I did immune to
Sorry.
Iraq.
Okay, there you go.
Oh,
There you go.
oh.
I don't know if
Sorry.
I put this up on Twitter the other day, but Florida is actually a really cool state, and I'm going to block the number out there.
Oh,
But
sorry.
we got these
I
badass
thought I'd go
license
ahead and show
plates
it.
down here in Florida, and you know that's something.
Good topic.
Yeah, it's the combat action ribbon. Somebody was asking me, what is that? And I was explaining to them, a combat action ribbon is like the holy grail for Marines, you know, and I don't know, just something to be really proud of. So anyways, on that note, how was your birthday? Did you do anything cool or exciting?
Happy birthday.
So for my actual birthday, like I'm an introvert, so I run a gauntlet every year. My actual birthday is the day before the Marine Corps birthday, and then after the Marine Corps birthday, Veterans
he
Day.
means he
So it's
actually
like
runs
3
a
days
gauntlet.
back to back, where I'm like inundated with calls and stuff. So, but my actual birthday was good. I just stayed home with my family. I'm an introvert. I did go to a ball last week with the Sergeant Major of the Marine Corps, the TCOM one. It was really great. I saw my first company gunnery sergeant. He's a legend. Sergeant Major Tane, 2nd Battalion, 8th Marines. He got a Silver Star for getting wounded in a push through Nasiriyah right after they found Jessica Lynch, the Army girl that got caught.
Just wondering if we should
His
speed
truck
it up
got
a little
hit with
bit.
like an RPG, and his hand was all messed up, so they medevaced him out. He woke up in Kuwait, and long story short, he stole a lieutenant's
We
camis,
need to speed it up a little
hopped
bit.
on a flight, and got an Air Force flight, and got all the way back to the
Look at
regiment.
the ghost
They picked him up, and they were
insignia.
like, "Well, we got to do one of two things. We're either gonna have to court-martial you or give you an award." So they gave him a Silver Star.
Wait, they gave him a Silver
the
Star
fuck?
for stealing someone's camis to get
What
back in the
fuck,
fight?
Gal?
Oh, I think
He got wounded and went back to fight. He all the way back to Iraq. And this is like the
Manly
initial invasion, the
hands.
initial push. So
These
the
guys are
door
so
to his
weird.
Humvee is actually still in the battalion
These guys are
headquarters.
so. Oh, you
or
wouldn't
wall or
play it?
something. So
Oh,
he's
okay.
a
I won't play
legend,
it.
man.
I won't.
But he was there. I saw him.
Okay, I won't play it. But this is a bad thing. She's very bad. I hate this woman. Lindell really built her up. He really created a monster with her. They're the ones who are running. She's involved with Cause for America too. So they're all kinds of crazy. Nobody likes them. We'll listen to their. Oh yes, please hot mic it. Please hot mic it. We can run it and see if there's. Oh, okay, no problem. I got it. Nobody needs that nonsense. Nobody needs that bullshit. I think we're gonna lose. What do you think? I'm pretty sure we're gonna lose. I think we're gonna lose. Do you think? Who's that? Who's that? Who's that? Who's that guy? Who's that guy? Who's that guy? Who's that guy? Who are those guys? Who are those guys?
Oh, yeah.
Who are those guys? It's a terrible jacket. Can I just say that's a terrible jacket? I like a good color. I love green. Oh my goodness. I love green. Like if that were a hunter green, I think that'd be beautiful. Pine. Even like a deep peacock would be beautiful. But that kind of like green stamp bookwood green. I don't know if it is Cheese Bros lawyer, is it? I don't know. But he's somebody. He's Proud Boy lawyer. I think we called him Proud Boy lawyer, but maybe not. Maybe that was the other guy. Bonnie looks particularly relaxed. Deep peacock is such a beautiful color. Can I just tell you right now? It's like, oh, there you go. It's the Masters. That's what it is. Thank you, Max. It's the Masters jacket color. What the fuck? I just think the peacock or like a hunter, not hunter, maybe not a hunter green. That's probably too, but like a pine, like a dark pine, you know? Do you understand what I'm saying? Are you picking up what I'm putting down? Yeah. Because I'm all over green. I love green. But some greens are bad. Augusta green. Yes, Augusta green. Augusta green is my new that's my new porn name. Hi, it's Augusta Green here. I don't know if I have any caps in the window, but I'll be our and I'll put on the screen. I look like shit today, but I don't care. I really like hair.
You know the people that you can touch with. I tell you what, I'll pass you along. My mom.
Forest. Thank you. Oh, girl, yes. Let's hope. I mean, why not? At this point, why not?
Leave your car out. You can just-
Oh, what happened? Where'd it go? Oh, there it goes. Okay, let's see what I'm not sure about this whole camera thing, but we're gonna figure it out. Let's see. Oh, you can see the cats. I know it's really bright. I want you to see like the cat tower. Hold on. Hold on. What? What do you mean you're not doing that? Why aren't you doing that? Darling, you must. Standard 480? Yeah, I think that's okay.
Someone come to order, man. See it?
I know my hair looks like crap. I don't care. I'm gonna go out in the sun later. Anyway. Howdy. I was hoping the cats would get up on the thing. Hi, Jim.
She's still on?
Scott Grubman says she's really lawyer. Is that
All right,
that
we're
guy?
back on the record. Miss Willis.
Is it him?
Waive any opening, closing, and I'll reserve everything until the end.
I wonder
All
why
right.
he's talking.
The state would still have the burden for revocation, so we'll turn it over to the defense. Mr. Kaczmarov.
Good afternoon, Your Honor. May it please the court. I think if we anchor ourselves to the words of the order that you entered, I think that's dispositive. And begin there because there's really three things that the state is complaining about. One is the concept of intimidation or harassment. Is that a subjective standard or an objective standard? I would submit, Your Honor, it's an objective standard. Otherwise, this order is vague. We wouldn't know what those things constitute. Threats and intimidation are well defined in Georgia law. None of these posts amount to a threat or intimidation. That is to say, none put a reasonable person in fear for their safety. The witnesses today you heard did not support that paragraph. That would be paragraph 5 of your order. There's no violations there. The remaining two paragraphs I would submit, paragraphs 6 and 7, there's no violations there either. Those two paragraphs state that you're not supposed to have any communication with a person or witness or a co-defendant in this case
Directly
about the facts of this case.
or indirectly.
That's what those two, directly or
Dude,
indirectly.
You're gonna lose.
So
this.
if you
This
look
is
at that
bad.
order, the only thing that the state tries to argue is that these handle tags on Twitter constitute communication. They said that over and over and over. The problem with that goes against Twitter's own help rules. And I
just happen to have a copy of them right
I
here.
actually brought it up on my phone, and I would ask the court to take judicial notice of that.
So there. Take judicial notice.
And it
of
says the
this.
ampersand sign
Ooh,
is used to call out usernames in posts.
let's do that. I need a little light.
Hello at X. People will use your username to mention you in posts, send you a message, or link to your profile. So that in the Twitterverse, that's used in a wide variety of ways.
Sure, but the practical effect is that the person mentioned gets a notification, do they not?
Yeah, that's the practice.
They do, Your Honor, and I would submit to you, for instance, Jenna Ellis has 1 million followers. I would submit to you, if you typed in Jenna Ellis and give the money back, you would see hundreds of thousands of independent tweets saying the exact same thing.
Okay.
So I find it hard to believe that Ms. Ellis would have seen that unless she were specifically called out about it, which is the other thing. None of these witnesses here contacted the state. The state shows of its own volition to contact them.
But just to be clear, what you're arguing is not so much that it was impossible that Mr. Floyd's comments reaching these witnesses, just that it was improbable.
I believe
It was
that is an
improbable, yes. It could
ampersand.
surely they could see that if it shows
If
up in
I'm
their feed,
not
surely they can see
mistaken.
it. But that's the other thing. Were they talking about the facts of this case? And I can go through each one of the Twitter posts that
Well, it says that they can't communicate, right?
not just communicate, can communicate about the facts of this case.
So,
what are the
for example,
facts
with
of
the
this
one with
case?
Miss Ellis, why
Let's talk
would
about it.
how would that not be a communication about the facts of this case if it's solely referencing a proper session?
Because first, it's public in the public domain, number one.
This
Well, that wasn't a precondition, right?
is an ampersand.
Of the bond
No,
order.
but she's not, I'm just pointing out the fact that her video is in the
Yes,
public
you
domain.
are.
He's commenting on the video. It is a public comment. He's allowed to do that under the First Amendment. So the idea that this is somehow not a permissible communication, it's a problem because that begs the question about the facts of this case. What facts? The ones as they develop, the ones that are ongoing, the facts in the indictment, which also spurs another question. Miss Ellis won't even be a witness against us. I mean, I know that the state's going to say, well, she's a RICO witness. We don't have anything to do with Miss Ellis. Not only that, we don't even have a witness list. All we know, we have unindicted co-conspirators. We have to guess who the witnesses might be. Now, the state has said that they have sent us discovery.
Thank you.
But that discovery is like a football field sized haystack about 10 feet high, and we're looking for 5 needles in it. I have to go through 30 or 40 folders and click down only to find out that the file that I'm looking at is a GIF image. So the idea that, we turned it over. I don't know if they turned it over. I had to search. I had to ask the other day for one of the witnesses' grand jury testimony that they said they had just received. So I don't know what the state has or what they don't have. I don't know who their witnesses are.
It's the great bluegrass sensation.
That's of no concern to me.
Sure, but I think you have a pretty good indication of who they're going to be. At least some of them.
I didn't know Gabriel Sterling was a witness. Had no idea, Judge. Zero.
But what about the Secretary of State?
Right, but that's also a public account. He's not barred from calling out the Secretary of State. Now, if we don't like that, we should change the bond order. I would submit, Judge, that would be the appropriate remedy. The state surely, and you read my motion, the state, or my opposition rather, the state knows how to address social media posts as it did with President Trump.
And so, again, this idea that someone has pleaded guilty and an explicit condition of their plea is that they're going to be a cooperating witness. You still don't think that's sufficient notice that that person's going to be a witness in the case?
No. I stipulate. So we're clear on the record. She's a witness in this case, not against him.
Well, she's a witness in the prosecution against him. He's going to be sitting presumably at one of many tables, and it will be in the state's case in chief where he is a defendant.
I may be presumptuous in thinking that won't happen, but Judge, she's a witness to be sure, but nothing in that bond order prohibits him from contacting a witness.
Stop.
Nothing in the bond order prohibits him from contacting a co-defendant. They just can't contact each other about the facts of this case. They could call him and say, hey, you want to come over for dinner tonight? As long as we don't talk about the facts of the case, they can do that. That's why I pinpoint those words. Communicate with. That's the other part of this. It's not simply to shout out into the Twitterverse. That's like going to Mercedes-Benz Stadium and being on one side and Miss Ellis is on the other side and during the middle of an Atlanta Falcons game. And he yells out, hey, Jenna, give the money back. If she happens to hear it, maybe the crowd starts chanting, give the money back. She's a public figure as well. 1 million followers, Judge. 1 million. She wasn't worried. She didn't know anything about it. She didn't reach out. So we're not contending that she's not a witness. The thrust of this is collusion. Are you getting together with other witnesses to change stories? I don't see any other purpose for those paragraphs 6 and 7. So I would submit, Your Honor, if we pay attention, if we're faithful to the text of the order, paragraphs 6 and 7 are clear. Communicate with, not communicate to, not say something about, because that's what this really amounts to, say something about. You heard Assistant Chief Hill, I believe his testimony was, he didn't know what was in the mind of Mr. Floyd. Mr. Sterling contended that one of the posts, or he agreed, one of the posts he wasn't even sure what case it applied to, but he knew there was another case pending that had sealed ballots in it. So yes, when you're tagged, it shows up in your feed. But like I said, Judge, you're not required to. It's not a requirement in Twitter. People post. I post things all the time where I will put an @ symbol. Do I think that the other person might see it? It's possible. I don't care. I want to post. It's a political forum. That's the whole purpose of ideas. You find something offensive. You don't have the right not to be offensive. I mean, in order to think, you have to risk being offensive, do you not?
So, yeah, just taking that point, I just want to focus here. I think maybe the Twitter aspect of this may be confusing it, but what would be the functional difference of Mr. Floyd having just written a letter and mailed it to him and assuming that Miss Ellis gets 1,000 letters a day?
Because that shows his intent.
Which one does she open?
His intent is to make direct contact. There's a mechanism in Twitter for direct contact. You can send a message directly to the person. as opposed to the Twitterverse, the forum, the public forum,
Believe me,
putting out
the
a
Twitterverse
political
is
message, a political
anything but-
opinion. He can do all
a
of those things. He
forum.
can say,
Might
know,
be
I'm innocent.
Caligula.
I didn't do this. Now, is he talking about the facts of this case?
Yeah,
Well,
it's the forum
I'm
where
sure the
Caligula
district attorney will
happens.
try to use this stuff at trial, perhaps.
Jesus Christ.
But Harrison Floyd has never said that anything against Ruby Freeman. By the way,
Oh.
Ruby Freeman doesn't even have a social media
He's
post.
never
And I want
said
to
anything against Ruby Freeman.
bring
By
this
the way,
report up. I would encourage you, Judge, look at page 2. A majority of these mentions related to commentary about the latest post from the Gateway Pundit regarding Ms. Freeman and Mrs. Moss's alleged participation in election fraud. Her attorney said this report was about his posts. I don't see how you can compare the two. Gateway Pundit has a slew of followers.
I look like I'm sitting
His
in
Twitter
the
account
hall,
is
but
25,000 people,
I'm not. I'm sitting on a
not 2 million, not 3 million, not the million that
A
Jenna Ellis
pundit.
has,
He's
not the
a pundit.
75,000 that Mr. Sterling has, or the 114,000 that Miss Willis has on one of her accounts, and
We're gonna argue that.
however many
it's
others she
not
has on her other
until
account.
Until we can't argue.
A lot of this
it
has to do with being in the public domain as well.
Domain.
Nothing in any of the posts that
Was
he
she
wrote
copyright
about Ms.
free?
Freeman show any threats of intimidation. They are merely statements
That's your
that he
opinion,
is claiming,
counselor.
I'm innocent, I haven't done anything wrong.
Gateway pundit.
Which is why I said in my motion,
The pundant.
or my opposition rather,
Fondant.
that
The
this
gateway
court should be
fondant.
faithful to the text of the bond order.
Those
If we have an
cake
issue with it,
designers, man, they get confused.
Judge,
all
we're
the
very
time with
amenable.
Gateway pundit, and they're
You heard
really
my
upset
my
because really they're
co-counsel
just
say
a
earlier,
gateway
all they had to
fondant,
do was call us.
you know. Right?
Mr. Floyd has come back
My
to Georgia
following
voluntarily.
feed is littered with judge stuff,
The
and I
first
don't
time when he turned
follow.
himself in, he
I
was
know,
put
some
in
of my
jail,
followers
wasn't able to get a
never
bond
see
hearing
that.
until Your Honor
I've
got
given up on
involved.
shitter.
You got back and were
Shitter is-
able to get him a bond.
He's a shitter.
He appreciates that immensely. He came back
Full
today
of shitty people.
just because I told him to. He's a law-abiding citizen. Yes, there are some other things pending, but that has nothing to do with this hearing. Zero.
He didn't do it. If he did it just
If you
because
ask-
you
if the
told
court
him
tells
to,
him,
that's not
Look, I
law
want you to tone it
abiding.
down. I don't want
Do
you to mention
understand
Ruby
what
Freeman.
you just fucking
He'll
said?
do what you tell him to do.
Buttercream
It's not
is a
that
gateway
at that point, it's not about
fondant.
a First Amendment argument. We'll let that go, Judge. If he's got,
The
if
poor
his
people at
rights
Gateway
to speech are
Fondant are
in
just
jeopardy
like, "Damn
versus his
it.
freedoms and
Damn
liberty,
it.
his personal restraint, Judge, he's gonna opt for his
Anyways,
personal
I want
liberty.
you guys to see, like, the cat.
So I would submit, Your Honor, that this whole tactic
You don't need to see
is
it.
somewhat
Oh,
of a
actually,
retaliation.
know
If you
what
look at
need?
the, when
Like,
the
you
motion
need
was
to come in like
generated,
this so that you can see the back.
I believe the motion was generated on
Otherwise, it
November
blows it
15th,
out.
just after this court's hearing, because we received it 2 hours after the court's hearing on the protective order. Ms. Willis was in DC. She personally signed the motion, or they put her signature on it. She was attending
Or
an
they
event with the Women's Summit
Yeah,
and also a fundraiser.
women.
But the reason why I say it was cobbled together hastily was because Jenna Ellis's post is
Now
on the
you want
13th,
what?
and she says
Now I want cake.
she saw it a couple of days later.
Ew.
Well, I would submit, Your Honor, that she was raised, the awareness of that
Yeah,
was
that's
raised
true.
to
Take a
her by the
bandwidth.
state.
I'm gonna take a bandwidth.
I just don't see a million followers, how that could happen. And so with that, Judge, I would just check one thing here.
I would say I lose. Goodbye. Mama, I'm gonna go out singing.
Yes, and there's also on Twitter, if there's a post that's found
Let's see
offensive
what's a good-
or
what's a good
threatening,
exit
it can be
song for this
reported.
guy.
and people should do that. If they want to generate reports, they can.
I don't know.
It would
I
be
keep
just as
thinking of,
effective to
like,
call out posts
Chicago.
and say these are inappropriate posts. So, with that, Judge, I
Do do
conclude.
do 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 do
Please stay be heard.
do 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 do.
Your Honor, it's always like when me and the defense can agree. We agree on something. We just ask you to strictly rely on the order that you sign. And as Your Honor knows, I only have to prove he violated this order one way, and that would be enough to revoke his bond. So I'll lead you to number 7 that says the defendant shall not communicate in any way directly or indirectly about the facts of this case with any person known to him or her to be a witness in this case, except through his or her counsel. It's clear they signed it, they understood it. Now I'm gonna take some time and go through a PowerPoint. I didn't ask any questions today to offend you. I asked you because of the absurdity of their argument. My team asked me to tone it down because I referred to it initially as lunacy, and they asked that I refer to it as absurdity. I would submit you can use either adjective. I need a screen share, Your Honor.
Which account is joining to
What account is
host,
joining?
Mr. Wooten?
It's under my.
All right, just one moment.
Technical Hey, now it's the time for Josh and Phoenix to shine as the AV team. Yeah.
No, I apologize.
I love her. I
So it's
really
limited
do.
to
She's
scope of
so
my
good,
argument.
Max.
We'll see if there's a point that needs to, we can go back and forth and back and forth. We don't need to have strict guardrails for argument.
There you go. It probably is.
Your Honor, just very quickly, Harrison
pretty
Floyd was
limited.
indicted by a Fulton County grand jury for count 1, conspiracy to violate, count 2, conspiracy to commit solicitation, and count 31, influencing witnesses. He entered a consent bond on August 29th, 2023. The language was plain, and I still contend he violated 3 of the 7 conditions, those being 5, 6, and 7, but I just need one of them. Your Honor, the law is clear. It is clear that the trial courts have the power to revoke bond as long as minimum due process is applied. Your Honor, by this hearing, you've given him due process. The trial court has authority to revoke bond if following hearing, the trial court determines that the defendant violates those conditions. It is clear he violated the conditions. The standard of proofs in matters initially setting a bond, the state has the burden of proving by a preponderance of the evidence that the trial court should deny bail to protect the community. Proof by a preponderance simply requires that the evidence show that something is more likely true than not. Condition 5, he shall perform no act to intimidate any person known to him to be a co-defendant or a witness in this case, or to otherwise obstruct the administration of justice. We've seen these posts, but certainly contacting the Georgia Secretary of State and Gabriel Sterling and calling them derogatory names is a way of intimidating. Whether it actually intimidated is not the result. It is, was it intended to intimidate? Moving on, he's about to go through some things.
She was so silent.
Your Honor's been practicing criminal law a while. Moving right along, this offense of Jenna Ellis, and I was going to point it out, but you already did. How we can contend that a proffer is not evidence in this case, and you're so dense, you don't know that the proffer is evidence, when in her proffer, the condition is that she's a witness. They want me to say it's disingenuous. It's a lie, Your Honor.
Wow.
This is Jenna Ellis. It's already Exhibit 23. I saw it a couple days after it was posted. Yes, I believe it was meant to both intimidate me. So does everyone else in the world who saw it, and to harass me, and also encourage others to harass me. That is common sense, but the witness has told you that is what she feels about it. Also, the negative comments that once again that Ms. Freeman has had to endure now for multiple years based on lies, he made sure that we're right back in that posture. Yep. And it's unacceptable. It is unacceptable for democracy to work. We need little old ladies to come and volunteer to be poll workers. And what this lady has received is a pattern of being lied on and intimidation. And he started it again. And I think we can both agree, being called outside of your name, older lady, I don't want to offend Ms. Freeman again, by this is disgusting, and it is as a result of his posting images, which are also evidence in this case. No one can deny, if you read the indictment, which they have been provided, that this is evidence in this case, which is why she's mentioned 40 times in the indictment, but they want you to believe they don't know she's a witness. It's ridiculous. I'm sorry.
She's angry. I agree with you there.
She's
with
angry.
all the posts about Ms. Freeman, those are ones where she is not tagged. And so I know that we have State's
Don't
Exhibit
you
22
dare.
showing that there is a reaction just to simply mentioning her.
There's a report. There are reports in media.
Would
Judge.
you
Come on
agree
now.
with the defense that Mr. Floyd there's nothing prohibiting him from publicly criticizing the state's case generally?
What I would agree is that when he signed a consent order, and the First Amendment can be limited for parties in a lawsuit, and Your Honor limited it. And the case law is very clear that there is a public good of keeping the community safe that you are required to do, which is why you made those limitations, and that his First Amendment rights to say whatever he likes,
I think she's trying to
if they
set a precedent
interfere
for the
with
other
the
people.
trial of a case, can be limited. And I'm going to take
And
Your
no
Honor.
question that they can be limited. What I'm wondering is, though, were they limited here to the extent that he couldn't talk about the case at all?
They were limited in the fact that he could not talk about the facts of the case, referring you again back to paragraph 57. It's not ambiguous, it's clear. It's the black letter. Cannot talk about the facts of the case. This video of Ruby Freeman are the facts of the case, and it's in the indictment. Let me read you some of the law that we have, and this comes straight, Your Honor, from a Supreme Court of the United States case, State Seattle Times Company versus Reinhardt, February 21st, 1982. So this is not new law. In the footnote, parenthetical 12 of 1718, although litigants do not surrender their First Amendment rights at the courthouse door, those rights may be subordinated to other interests that arise in this setting. For instance, on several occasions, this court has approved restrictions on the communication of trial participants, which he's a named defendant, he clearly is, where necessary to ensure a fair trial for a criminal defendant, which this could have impugned not only on his rights, but his 14 co-defendants still remain with him. Also, Your Honor, it says in that case, in the conduct of a case, a court often finds it necessary to restrict the free expression of participants, including counsel, witnesses, and jurors. Your Honor, you restricted it when you signed this order. Not only, what makes this so disgusting is he consented to this order. So this wasn't even put upon him. He agreed to this order. They want to tell you about 5 days. Those were 5 days he chose. They know that we tried to work with counsel, but that's irrelevant. He was given the benefit of the doubt. He was treated like every other defendant, although he had an open case. He was given an opportunity to cooperate with the rules of this case. And what he really did was spit on the court and refused to oblige by 3 of the 7 conditions of this bond order. So no, he does not have the right to communicate about facts of this case with witnesses, which he did with Jenna Ellis, which he did with Sterling, which he's very well aware of and was served. And it is not the state's fault if the defense is unprepared, which was their argument. We're unprepared. We don't know what's in the discovery. Not my problem.
How is he communicating with Ms. Freeman in this post?
When you put something on a social media page
on a
that's
social
viewed by
media
400,000 and you put it in an open space, you have the ability to indirectly communicate with Ms. Freeman when you put it in the public space. Perhaps they could have some sincerity in that if he had a closed page that was not watched by many.
There
Do
you
you
go.
understand
That's
what I mean by a private or a closed page? That is not the status of his post, which is why close to 500,000 people saw it. Again,
That's Bonnie
response
Ellis.
mentioning Jenna Ellis.
It's
Again, I guess
Bonnie.
they want you to believe they don't know Jenna Ellis is a witness in this case. On and on, Your Honor, and you have it. And again, I don't want to waste your time. And the response is just what you could expect. Miss Ruby needs a bodyguard or she's going to get Epstein. This is a direct result of his conduct, which is why you, as the trial court, have a duty, and in fact did your duty, to keep witnesses in this matter safe.
Yep.
Moving right along, if she'll live to see this day, there's no denial that as a result of his conduct, a witness was put in greater harm and greater hate was again spewed against someone that's had to go through this for 3 years. Condition 6, he shall not communicate in any way, directly or indirectly, about the facts of this case with any person known to him to be a co-defendant in this case. I guess they want you to believe they didn't know Jenna Ellis was a co-defendant. You can look at the post. It's part of the record in here. Jenna Ellis again saying she saw it, which means there was an indirect communication with him. Your Honor, I just need to prove he violated the order once. He knew what he was doing. They signed this order. They agreed to it. There was a good reason to have an order with these conditions. And what we're really here to decide today is, does this order mean something or not? He doesn't get I'm sorry, after I've already intimidated the witnesses in this case. It's too late. You should not have done this. You knew it was against the rules. You put someone in danger as a result of doing it. And now you need to be held accountable for it so that we can make sure that all of the defendants in this case get a fair trial and that witnesses are kept safe. Moving right along, Your Honor, you'll have all of these in your communication. There was some debate, again, lunacy and absurdity, that we don't know if this is Harrison Floyd. Your Honor can look at the post and see his image tying this to him.
Oh, we have that.
Jenna Ellis again in these posts. Authority of the court. Bonds in both felony and misdemeanor cases may contain conditions so long as the conditions are reasonable under the facts and circumstances of the case. I would suggest the conditions you gave him were reasonable, which is why they signed up to them and agreed to them. And Your Honor, it is not. We limit Fourth Amendment rights all the time in giving bond orders, giving someone the right to search. Same thing with First Amendment rights. Authority of the court. One of the court's functions is to balance the defendant's rights with the interests of the public. The public is Ms. Freeman, who served, keeping her safe. The public is also Ms. Jenna Ellis. The public is witnesses and jurors who will come and testify. Here, the bond conditions are not arbitrary and capricious because the conditions are a reasonable response to the trial court's functioning of balancing the defendant's rights with the public's safety interests while avoiding the intimidation of prosecution witnesses, which was the exact purpose here. But Your Honor doesn't have to find it was intimidating. You can say, you know what, calling witnesses pieces of shit, it don't even matter. I don't find that to be intimidating. Do you find they communicated?
That's on the record.
Do you find that they communicated with co-defendants? Do you find they communicated with witnesses? If you find that, then you find that he violated the bond order, and you have to decide, do we have an interest as a society in keeping witnesses in this case safe? Do we have an interest in this case of keeping the other defendants from having a fair trial? Authority of the court. Although litigants do not surrender their First Amendment rights at the courthouse door, those rights may be subordinated to other interests that arise in this setting. For instance, on several occasions, this court has approved restriction on the communications of trial participants, which he is, where necessary to ensure a fair trial for a criminal defendant. There are other criminal defendants in this case. In the conduct of a case, the court often finds it necessary to restrict the free expression of participants, including counsel, witnesses, and jurors. Again, the site for that is Seattle Times versus Reinhart, 467 U.S. 20, 1984. Defendant Floyd violated his bond, and it should be revoked. OCGA Ayala sets out 4 factors a court must consider when setting a bond, including he violated 3 of the 4. His rhetoric poses a significant threat or danger to witnesses in this case in the community. He poses a significant risk of committing a felony committing trial. He poses a significant risk of intimidating witnesses and otherwise obstructing the administration of judges. The absurdity of the defendant's argument. Defendant falsely claims that he does not know who the witnesses are. Your Honor, that's just a lie. It's just a lie. There's no other thing to call it. You're not aware Jenna Ellis is a witness? So I know that it annoyed you to ask that question, but I wanted you to see in their own motion, they know she's a witness, and they should not have told you that. Defendant Floyd in his own motion refers to Jenna Ellis as a witness. Defense motion, page 8, line 9. Defendant Floyd in his own motion refers to Ruby Freeman as a witness. More absurdity. In indictment number 231888947, Ms. Freeman is mentioned 40 times, but putting the defendant on notice, she is a witness. In indictment number 23SC18947, Secretary of State Raffensperger, who he tags, is mentioned 4 times. I think that puts them on notice that he's a witness. The defendant has the witness transcripts of the Secretary of State, Mr. Gabriel Sterling, and Ms. Freeman. They are aware with these witness statements that they are witnesses. Defendant states in his motion affirmatively that Mr. Floyd's post did not stir the pot against Ms. Freeman. Really? You saw the post. It absolutely stirred the pot. And so for them to put that in their post when they saw, as he called them, the ugly, racist, violent comments, that is a direct result of his conduct. However, a cursory review of the response to Mr. Post show that this to be another lie. Miss Ruby needs a bodyguard or she's going to get Epstein. Ruby is, if she lives till a trial. I'd love to see her daughter in the slammer, 2 corrupt losers up to it. Bury this under the jail. Ruby should be in prison. She's a racist. Because he's the one that's scared she's afraid of white folks. Racist pig. It's no question that that is not true. Dirty damn rats. All of it is untrue, so they should not have stated it in their motion. Defendant wants this court to believe when you tag someone in a post, it does not notify them. The entire purpose of tagging someone is so it hits their feed and they see the post. Take judicial notice of that, Your Honor. You don't even have to, though. You have witnesses testify to it. They make this silly argument because it is clear that it's communication in violation of the bond order. They know it's communication. I'd submit to you it's direct communication. But it doesn't matter. If it was direct or indirect, he violated his bond order. In 2020, Ms. Freeman and her family members were intimidated by people as a result of her name being disclosed on social media. And it is this intimidation which Mr. Floyd was indicted to represent to the court that his recent post of accusing Ms. Freeman of the exact same things that were done before and indirectly targeted Ms. Freeman is absurd. Defendant wants this to court to believe that the last thing Mr. Floyd wants is for Mr. Freeman to form an impression he's somehow against her. Except his post show that.
Yeah.
Yet it is Mr. Floyd accusing Mr. Freeman of his post of being a fraud. Your Honor, all we're asking you to do is exactly what the defense asked you to do. Read the court order. Look at the evidence.
That's what
He
I'm
violated
saying.
this court order.
I'm saying this
It is unfair
this
to those witnesses
so
that are
she
just
can
coming, first to do their public duty as an election worker,
set the precedent.
and second to do their public duty as a
Of
witness.
course I hope.
And there are real consequences for allowing defendants to intimidate witnesses. Your Honor, we're asking that his bond be revoked and he be remanded today.
Jolly Ranchers. Jolly
All right,
Ranchers.
I'm going to allow the state the last word, but Mr. Cashrow, if you have a few other points you want to make.
Yeah, I'll be brief, Your Honor.
Jolly Ranchers.
Your Honor, as you know, I've not ever contended that Miss Ellis isn't a witness or that we didn't know she was a witness. I'm not sure where that came from. My motion said, our
You said
opposition
it.
says she was a witness. We admit that.
Bitch.
The state's argument is that anything on social media posted about, that Harrison Floyd posted about this case is automatically
That is not.
an indirect communication, if not a direct communication. That's absurd.
You're absurd.
And that's where we're running into trouble here. Judge, I would submit you focused in on one particular tweet, which was Jenna Ellis. And I want to go back to her tweet. That tweet is a shout out to the Twitterverse at large. Yes, I think it walks up close to the line, but if you understand the world of Twitter, or X as it's now called, that's not how people communicate. It's a very ineffective way to communicate. If he really wanted to communicate with her directly, he would have simply sent her a notification and called her a liar or whatever. And he could have even called that out. That would have been a clear violation of the protective order. The other point that the district attorney made was that, oh, we said we didn't stir the pot. Yeah, we didn't stir the pot. You see, the district attorney stirred the pot. They've been stirring the pot since he got arrested, Judge.
What?
From the very first occasion, I never got a call about Mr. Floyd getting bond. Rather, I have Miss Willis and Mr. Wade apparently recorded my colleague up in Maryland, which, by the way, it's a two-party state. It's a felony to record without permission up there. They recorded my colleague, and he said, I don't know anything about the bond. I was handling his case to come here to Georgia. So this idea that he's been given all these chances, et cetera, I think that's hogwash.
He's an adult.
This idea, though, that we didn't stir the pot. All the evidence that you have, the views, they're wholly dependent, Judge, when they were captured, when you looked at Twitter and when you captured that image.
Which means there's more now.
When they filed this motion to revoke bond, just like when they filed the motion for the protective order, if you recall, Judge, I was in court and I said we had gotten numerous calls from the media that they were pestering us, and you said, well, we should all expect some of that. And I agree, we should in this case. But this is not exactly right, because when they file a motion to revoke his bond, they're all in the back watching us. When they file the motion, it immediately causes a spike and everybody starts searching everything. So they can't use that as evidence against Mr. Floyd.
I don't know if this is the best argument.
I think that is absurd.
It comes up in your notifications.
The other thing I would leave you with, Judge,
in the little
I really believe that the words of this court order are pretty clear. And I think the only thing that you have to discuss or to analyze today is whether you believe he was communicating with Jenna Ellis in that one post. I think that's the only issue that you are faced with, because it's an indirect tag. Now, it's not an indirect communication, and as I've said, the Twitter help file is just dispositive on that. It's a shout out to the Twitterverse. Could it be used as a direct communication? Well, indirect. I'm sure it could be used as an indirect communication.
Well, then that's okay.
But if you search yourself, Judge, and look up Jenna Ellis and send the money back, I think she raised over $200,000 and before she entered her plea, you'll find hundreds of thousands of posts telling her to give it back. Now, maybe she was directed to Mr. Floyd's at some point by the state. I don't know. We don't, and we should not.
Does it matter? If a tree falls
Chill
in the
speech.
forest and Jenna Ellis doesn't see it,
He
did it
has the
fall?
right to make political
Did
speech.
it fall on her?
He has the right to talk about the facts of this
No,
case
she wasn't there.
in Twitter. As long as he doesn't communicate with another defendant or a witness.
Okay.
And we don't know all the witnesses that are in this case. Like I told you before, I know a fair number of them, but I have a list of
Oh,
unindicted
So now you
co-conspirators that I'm
don't
just
know?
trying to figure out who they are.
so you don't know who's?
We don't exactly know. I don't have a matrix of
Well,
that.
if you
If
didn't
we
have
do,
knowledge of it, you wouldn't be.
it's in the
brought
discovery
front of
somewhere, and
the-
we're still
you
searching through
wouldn't be
that
brought in front
morass
the
of
judge, would you?
information.
Would you?
So you were not provided the witness list used during the trial we had prepared for Mr. Chesbrough?
No, I was not, Judge. I don't recall getting that list at all.
Really? Because Mr. Chesbrough.
If they did, I would not, I couldn't sit here today and tell you they didn't
That
put
you
it with
hugged
this
her on the
mountain
way
of stuff, but the way they turned over discovery, I've never seen anything like it. They just
Tagged her on the
handed,
way
you know,
down.
80
That's a good
folders
one.
down, you
win,
find this one
Jen.
little
That's
GIF image, a
better.
little
Better than my
picture
joke.
that belongs to another file that's down the
Therefore,
same,
she knew
a
about
different
it.
tree, 50 folders.
Therefore, the tree
It's
fell
it's
on her.
absurd. That's absurd.
Theoretically.
So at the end of the day, you know, I think the rule of lenity is appropriate here. You know, if the
What
court
kind
feels
of
that something
tree?
is amiss,
I
or you
want
want to
to
correct
know.
something, or we need to make something more clear, I think we need to give Mr. Floyd the benefit of the doubt.
It's a
This is not giving him a
half
second chance. I'm not asking for that because I don't believe he violated the words of the bond order. I think the bond order is crystal clear. Do I think he walked up close to the line? Yes, he did.
Oh, well. You
Have we had
just
discussions
admit-
about it? Sure. But in terms of the last part with
you
the
just-
13th
you
and
just
14th,
admitted it,
when we
Nancy.
were
I don't know
accused
what
of,
that means.
quote, leaking a
Complains
video,
about- yes,
that
you
video
just
wasn't
complain
leaked.
about
There was no
every
protective
case.
order on any of those proffer videos. That wasn't even a leak. Yet Mr. Floyd's
even a leak.
November 13th and 14th posts are responding to that purported leak because the district attorney absurdly put in that a typo from my
Absurdly.
colleague where he said, "We are the source of the leak." And he then sent another
Absurd
email
is the
back pretty
word of
quickly
the
that
day.
said, "We are
That's
not the source of the
absurd.
leak. I'm sorry, that was a typo. I typed too fast." They did
Anytime you hear
mention
you
that it
have
was a
to, like,
typo in their
drink or smoke
motion,
or
but they only
something.
included one email.
Absurd.
The press picked up on that one email and things started to go crazy. That's the nature of this case. So if we're going to limit speaking, you know, every time Miss Willis goes to Washington, D.C. and attends one of these events, we get spikes in Twitter. The same time
Really? I
he was
didn't
making
even
these
know
other
she was
comments.
there.
That's when she was in D.C. at these events.
Absurdity.
So
Absurdity.
the words of the court's order are clear.
Absurdly.
The burden has not been met by the state for the, and I'm positive the burden has not been met for the
Absurdity.
concept of intimidation. That's a legal definition under Georgia law. And it requires one to be objectively and put in reasonable fear of harm by the words that were spoken, not by responses, not by any of that stuff.
Okay.
And then with respect to the last two, paragraphs 6 and 7,
And then what?
you won't communicate with.
All right.
It's alongside it. I won't go to this man and say, I communicate with you.
Despite
I
saying what?
want to talk to you,
Hold on.
as opposed to me addressing you here, knowing full well he can hear me. And saying, well, John Morrison is our co-counsel. I'm not communicating with him, but he can hear it. So the idea that he didn't communicate with about the facts of this case, as I want to express to Your Honor one more time, it's not that he can't talk to a witness or a co-defendant. What Ms. Willis said about that is absolutely incorrect. That's not even what the court order says. The court order is specific. You cannot talk to another witness or co-defendant. You cannot communicate with them about the facts of this case. The whole purpose of that number 6 and 7 is to avoid collusion. That didn't happen here. What we have here are First Amendment issues. If you want to curtail, I would submit, Your Honor, we should adopt what the president's bond order, bond conditions, where they explicitly mention the First Amendment issues on Twitter, because the president is known for that. So if they felt that this was included in his bond motion, they should have put it in there. They had the opportunity to do that. Thank you.
Your Honor, I'm not gonna be long. The bottom line is the defendant didn't respect the order of this court. He violated it. If you have questions about intimidation, don't go to that paragraph. Go to paragraph 7. Although you have a witness, Ms. Jenna Ellis, telling you she felt intimidated, and Von Du Bois, who represents another witness, telling you that he interpreted, that his team, to include his client, interpret that as intimidation. But you don't need it. All you need is paragraph 7, which says he's not to communicate. This notion that tagging someone doesn't get a message to them is really lunacy.
Or absurdity, whichever word you prefer, Your Honor.
All right. I'm going to compile my notes and I'll be back in 5.
Back in
Give me a holding
5?
place.
Back in what? Back in 5? He's going to make one right now. Make a ruling right now. We'll leave the hot mics open. And then when I was 7, I thought I'd be a king. Hi, J31C. How are you? It is shittery. It is shittery. I tell you, sir, it is shittery. Hey, girl. Is it still possible to report threatening on Twitter? You really have to. It has to be like, yeah. He's got to poop. I mean, let's be honest. Let's call the thing a thing. There's some pooping going on in that courthouse right now. Compiles notes is the new way to say you gotta poop. Yeah. Everybody poops, even the judges. Everybody poops, even the judges. Cause that's what a healthy gastrointestinal system does. Yeah. I was hoping the cats would be up in the cat tree, but they're not. I don't know why. Sorry about that. Compiles the notes is the new pooping. This judge seems comfortable making judgments from the bench. You know what I like? He's just going to make this decision, and that's what I like. I like that. I think that's a good idea. Compiles notes, fecal emoticon, and that's absurd. Yeah. Fecal emojis are absurd, you lunatic. Fecal emojis are absurd, you lunatic. Fecal emojis are absurd, you lunatic. And then we send him to jail. Yeah. No, I think she's, in my humble, uninformed, not intelligent, really highly compromised opinion. I think she's trying to set the precedent so that she can hold other people in contempt of whatever, orders they're held to, and she can, follow through. That's what it sounds like to me. And this seems to be one of the most obvious cases, I guess, so far, although sure there's a lot of others. Oh, thanks, Jen. You're so sweet. Thank you so much. It's a super sticker. We're gonna do the super sticker dance. Super sticker. It's a super sticker. Super sticker, super sticker, super sticker dance, yeah. I won't remember that, but that's for you. It's a one-off. Yeah, I think she's doing this so she can put it on the record that if you super pump sticker, yeah.
Yes, he did say 5 minutes.
She wants it on the record that you can't do this, and that she will follow through, and da-da-da-da-da. And if she's successful, then she knows what arguments are going to work to be successful and what arguments are not going to work to be successful. And so this to me feels brilliant. And is it provocative? Absolutely. Does she know that? Absolutely. She's so smart. So I have no doubt in my mind that
Yep. Okay, and that's just the way. Yes. First name. Nathan. Nathan. I'm trying to.
Sorry.
Your name.
Daisha, D-A-Y.
Daisha.
D-A-Y-S-H-A.
S-H-A.
Middle initial D.
Daisha.
D. Young.
D. Young.
please speak louder.
Young. All right. That's good. D-A. I think it added an apostrophe. D-A-Y. S-H-A. Deja.
Shoot, how much time left? It's already compiled. Oh,
There's a Y after that. Yeah, I don't have.
compiled. I compiled earlier.
Asia, okay. Take that.
Yep.
No, you can just put them up there.
It's
He has them.
compiling the absurdity of it all.
It's we're good.
It's a
ADX.
super sticker.
We all have different titles, but that'll work.
Well, titles are important.
Wait, we need to hear the defense table.
Oh, okay, my bad.
I want to hear the defense table. Does everyone realize their mics are on?
Like one off.
I'm gonna flood the zone with my compiled notes. Flood the zone with your absurd compiled notes. But is it lunacy or is it absurdity? Which one, Your Honor? Which one? Is he back? He's not back. Oh, is he back? No. It's a super pooper sticker. I'm gonna go outside after this. Sit in the sun. But tonight is a members only movie. And I have a very cute setup. I'm going to point the camera at the actual big television, and it's like a pajama party. So if you are not a member, you still have time to become a member. Just join, hit the join button. I don't know where it is. And join. It's $1.99 a month. Come on now. Come on now. Come on now. Come on. Come on. So yeah, if you can become a member, that would be great, and we'll do it on. It's right here on YouTube to start until we get like I don't know if we'll get kicked off. I'm gonna point it at the TV. I'm not gonna like stream it. So anyway, yeah, that's later. That's at 5 p.m. Pacific, 8 p.m. Eastern. Everything in between and outside of that. 5 p.m. Pacific, 8 p.m. Eastern. Right here on YouTube. I still can't get into your Google account. No, but Badger, you just have to come to YouTube. Because you're a member, you'll be able to see the broadcast. So you don't have to do anything special. You just have to sign into YouTube just like you are now. Right. I know, I'm excited. So yeah, just YouTube. Until they kick us off or whatever they do. I don't care. We'll figure it out. We always do. We always do. We always do. What? What happened? I finally found you have to do something. All you have to do, Jay, is hit join. You just hit join and then tell it you want to join as a member. Thank you, Lee. Thank you for the super pooper sticker. We love the super pooper stickers here on the Lolo's Live. Yeah. Thank you, Lee. That was really good. Yeah, popcorn. Ooh, I'm gonna make popcorn too. That's a great idea. All rise? No. Okay, just kidding. Super pooper sticker. Yeah, Jay, do you see that on that join button? I don't know if you see it, but that's how you do it. I don't see you as a member right now, although I've seen you as a member in the past, so maybe it just expired. They expire every month, I think, which, is a good idea. I hate recurring shit, frankly. I'd rather choose. Not all make it past the hazing and initiation, right? Oh my God. Tell me about it. Boo-doo-boo-boo-doo-boo-doo-boo-doo-boo. Right? It's just one of those things. Oh, you have to get a laptop. Oh. Let me ask you if you get a laptop. If you go to my about, no, if you go to my channel page, there's a membership button, and you can be able to get that. You know you know how to do it. I don't know. Doesn't it? No sun? Oh, we have sun here. And I'm really excited to get outside. Yesterday it was super windy, so it was like really cold actually. It wasn't really a great day to sit outside, although it was a beautiful day. God, when it's beautiful and windy and clear, oh, so gorgeous. The hills are so gorgeous. So nice. I love it. But yeah, no. But tonight, it's a pajama party at Lolo's Lounge. Lolo Late Night, the members only pajama party at the Grotto. Let's call it the Grotto. That's a great idea. I think that's a great idea. I will be honest, one of the things I'm thinking about is ending the memberships because I feel like I want everyone to just like join in all of the activities. And so I'm thinking seriously about that. Because you guys are you're wonderful and you're generous and you're lovely. And I also want everyone to just.
But when I come to order, remain seated.
One of the beautiful things is us being together has been so wonderful. So anyway, that's my thoughts. But I can't do that tonight. I have to do the members only because November.
All right. Thank you all for your patience.
November. Your patience. That was very fast.
So just a few thoughts to share. And the first, I would just say.
I agree. No, I don't.
How we got here. At the outset.
That's a popular opinion.
I'll just note that.
No problem.
At the time of indictment, we were in this courtroom in the middle of another murder trial, so I was not able to conduct the first appearance for Mr. Floyd. But throughout that week during the trial, we were presented with these consented bond orders, which were negotiated by the parties, and that I signed without a hearing. And Mr. Floyd agreed to abide by the terms of it. And I think it's clear from the case law there is no constitutional right to bail. And a bond can contain special conditions as long as they're reasonable under the circumstances. And often those can curtail or even eliminate a defendant's constitutional rights under the First Amendment, under the Fourth Amendment, such as forbidding contact. We see that quite commonly. And the question becomes, a trial court has to balance the rights of the accused, as well as the public safety interests that are raised by any particular case. But I'll also note that a defendant is generally allowed to publicly criticize the merits of a case, to say that the prosecution doesn't have a case, to challenge the strength of the evidence, to speak his mind. And I don't see anything in this consent bond order that limited general criticism of the state's case. Each of these conditions had components to them, had preconditions, but there was no general limitation of talking about this case. But obviously that criticism cannot cross a line and ever evolve into witness intimidation. And I think as the defense was willing to concede here, Mr. Floyd seems very boldly willing to explore exactly where that line lies in this case. And I think the state has made a compelling argument on many of these points. But in categorizing these statements, on the first point of intimidation, we don't see, as we might see in these bond conditions, as they're traditionally understood, someone posting the personal info of a witness or a co-defendant. We don't see someone directly messaging, again, as that's traditionally understood. And
damn it,
we don't see in the wording an explicit indication that something ought to be done about these individuals or that they should be targeted in some way. I read these as seeing more that someone is wanting to defend his case in a very public way.
No, don't.
And so on the question of, and especially when it comes to the public officials, I think as Mr. Sterling testified, when it comes to intimidation, they've endured far worse than is presented in this motion. I think it becomes a much closer question when we start talking about whether this is direct or indirect communication. And we're getting into also kind of a question of at what point is someone responsible for the response of others? And I don't know if those are necessarily settled questions under the traditional bond limitations that we used and the phrasing that we used in this case. And ultimately, I think that, first of all, the defense argument that there's no knowledge that these were potential witnesses, that's not an argument that I'm buying. I think that we can't hide behind a veil of ignorance when certain witnesses have testified before the special grand jury or are very much known to be involved in the facts of this case, or just recently pleaded guilty and were known to have a public cooperation provision. I also think that when we're talking about the facts of this case, that is a broadly understood term. And if someone is just denigrating another person who's known to be a witness and talking in reference to their proffer, that's also satisfying that precondition. But when it comes to the question of indirect communication, again, I think it comes down to, while there may, I do think that in several instances here, there has been a technical violation of Mr. Floyd's bond, and that communications he made wound up before the eyes and ears of potential witnesses and co-defendants. But not every violation compels revocation. And so I am stuck on the question of notice, and that the bond conditions as written in my mind were not specific enough to account for the nuances of social media.
What?
So I think the ultimate result of today's hearing is that it's very clear to me that this bond needs to be modified. And I think it needs to specifically prohibit any public comment concerning Ms. Freeman, concerning her daughter, and concerning other witnesses that need to be included, because even if he's not directly or indirectly communicating with him, however we define that term, I think the public safety interests raised as a result of today's hearing indicate that his actions have a consequence. And because he's under the conditions of this bond order, the court has the ability to curtail and protect that interest. So
this was it.
Ultimately, what I would be asking for is for a recommendation from the state, but I would also allow the defense to respond of exactly how they would propose adding or modifying these bond conditions. And I will then take those under advisement and enter a modification on the record. And nothing from today's hearing should be seen as curtailing the state's ability to refile such a bond revocation motion immediately upon an additional violation. And I think that it also is very much dependent on the specific facts of the tweets and communications at issue here. And it can't be so broadly defined to cover all other co-defendants. So on the issue of modification, I think that's something that we can revisit and let time to consider, unless there's something parties would like to address now and want the court to be able to consider specifically what they would like to see as a modification. Or that's something we can follow up, but the court is available and ready to enter that as soon as it's conveyed. Anything, Ms. Willis, that you would like to add?
Obviously, we're very concerned about the safety of Ms. Ruby Freeman. She has clearly endured enough. And this conduct is not just chilling to her, it's chilling to other people who would want to serve in her capacity. So, you know, we respect the ruling of the court, but take exception. This defendant is very well aware of what happens when he tweets about Ms. Freeman. We do not believe it is appropriate for him to make derogatory comments about anyone. He can publicly criticize me all he wants. I don't value his opinion, it doesn't matter. But what he may not do is publicly do things that intimidate witnesses. And so that needs to be clear. he should not be able to tag them so that they are communicated with or put them in open space so that Ruby Freeman now may have to move again and get another advisement from the FBI. And so I would ask that before Your Honor leaves here today, that my team be allowed to sit down, that the defendant personally sign off on an agreement stating that and initial each clause so that it can be made more clear that he should not contact and intimidate witnesses in this case.
I don't have any concerns with what you've raised. Mr. Morrison, Mr. Kaczmarov.
Briefly, Judge, I'm not going to sit down and initial language that I haven't seen, number one, or had time to look at, cogitate, ruminate, pontificate over.
Don't give a shit.
I think the appropriate thing for us to do is what you suggested. We'll submit our orders. If you take what you think is appropriate and reasonable and enter it that way.
Let me see.
Then I'd ask you stepping back today, and then when we can get it worked out, then he can be loose.
Well, I think there's still time to the day. Why don't we see how far we get? I'm not going anywhere. And again, I don't think we're writing a treatise here, but I think there needs to be something more explicit and a little bit more definite. And it can be as all encompassing as we need to be. And if we need to go back on the record about that, we can. So how about
No
I
time
will
for pontification.
check back in with everybody closer to 5.
No time.
And we'll see where we are. And if we need more time, we can take more time.
What does that mean?
We do have several rooms. I think the state could use the jury room if they'd like to, and we can find a side room here if we can unlock that for you. Deputy Scott, is that unlocked?
Things.
All right.
Too busy being ill prepared, Your Honor. Okay, well, that means they're going to be in session for 38 minutes.
All right. So the adjoining courtroom is also open.
We have 38 minutes. Ruminate and cogitate, yes, and then we'll pontificate and aggravate, and we'll bloviate. I will bloviate now on my aggregate of my agate. Let me bloviate upon the aggregate of my agate. Let's find a fire. I'm really look at all my little reading tabs. Here's how great my reading tabs are. Let's see. Oh, this is the motion. So I actually have the motion.
Look over some motions.
I have the Ukrainian charges officials tied to Hunter. I got to read that. Oh, this looks fun. I'm reading this, The Original Fascist by the Claremont Review of Books. That's fun. What's this? I have no idea. I don't know. That's some case. Oh, what's this? Oh, this is the subcommittee reading room. Okay, that's all the extra shit. This is a new toy I found, Rumor Guard, which it's like you go here, rumorguard.org. It's part of the News Literacy Project. And they do these things like they debunk little things. No, ballots weren't stuffed or flipped or fabricated. Da, da, da. And then they go, learn more. No, 1936 was not hotter than 20. Anyway, so that's fun. And then what's this? What do we got here? Uh-oh, it's going to be embarrassing. Oh. Guess where I want to go? I requested tickets to this. Let's see who is speaking. Who's speaking? Is that it? I don't know. That's right, bitches. That's right, bitches. I'm gonna try and go to the thingamabobber. I'm gonna put on my best pearls. I'm gonna look like a fucking Republican, a grande. I'm gonna walk in there as a grande. Maybe I'll be. Oh no! You know what I'm gonna do? I'm gonna go get glammed up. I'm gonna have my girlfriend who does makeup. I'm gonna have her do my makeup and get like super glam. And then I'm gonna go to the tour as like this really gorgeous like Republican cougar. You know what I mean? Doesn't that sound like? Okay, wait. We gotta plan this out. Okay, first we got a lot to talk about. Hold on. Okay. Anyway, listen. Yeah, do not intimidate witnesses. That's a great tattoo. Okay, so number one, I want to go to the Reawaken America tour here in California in December. So I'm working on tickets for that. More to come. And I'm not going to be provoking. I'm not there to make a scene. I'm not there. I'm there to observe and listen and learn. That's what I'm going to do. That's it. So there's that. And that's middle of, it's going to be a very busy holiday season. Because then not next Sunday, but the Sunday after, no, not next Saturday, but the Saturday after, I'm going to LA Comic-Con, and I'm going to be live streaming from Comic-Con in Los Angeles. So that's exciting. I have to make my costume. So what I'm going to be doing, let me tell you what I'm going to be doing here. Let me show you. Hold on. Hold on. So let me see.
I'll see you around. Well, I got one. I've got. If I need to change, I'm good.
It's a good picture.
How's everybody looking?
Okay, here we go. It doesn't matter. All right. Wait. Meow. Chow. Chow. I'm going to dress up as this for Comic-Con. That's what I'm going to do. I'm going to dress up as that. That's what I'm dressing as for Comic-Con. It's in Los Angeles. It's at the, oh my God, Jen, do you want to go? Jen, do you want to go? Tickets are only $60. It's not that much. It's at the convention center. Wait, I thought I had it pulled up. Hold on. Let me go back. Because I thought, oops, sorry. I thought I had it pulled up. But that's where I want to go. Hold on. Let me go ahead and go to Comic-Con. I thought I had a picture of Comic-Con. No? Wow, I really thought I still had the Comic-Con thing pulled up, but I guess not. Let's see. What is this? Okay, that's that. Well, here we go. LA Comic-Con. All right. This is it. So it's at, what is it? Oh, the Los Angeles Convention Center. So just downtown. Get tickets today. It's in 10 days. I'm so excited. I'm going to be there live streaming all day. It's going to be amazing. Let's see. Whoops, no, I don't need that. I'm going to Uber, baby. Let's see. Entertainment guests. I don't know anyone. Matt Smith, Doctor Who. Jamie Campbell Bower, somebody else. Aaron Moria, who? Sweeney Todd. Yes, that's right. Joanna. Yeah, okay. Thank you. Aaron Moriarty. Okay, no. Karen Fukuhara.
The boys.
Oh, yes, of course. I know this isn't a quiz. But anyway, these are the people that are going to be at Comic-Con in LA. I know. I mean, of a lot of these people. Oh, Lateef Crowder. Oops. And Leah Clark. Steven. And Lolo's going to be there too. Da, 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 da. Do what you need to. Woo! Boy, those are. These are all the cosplayers that are going. All right. I want to meet all of them. I want pictures with all of them. It's going to be great. Panel schedule. Whoa. It's going to be great. Oh, wait. Are we back? Oh, no, we're not back. Okay. Oops. Oh, geez. What happened? Where'd I go? Oh, okay. Da, 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 da. That's not it. Da, 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 da. Autographs and photo opportunities. Oh my God, look at it. I don't know who that guy is. photo ops. You can purchase them. Pre-purchase photo ops. Let's see. Who can you take a photo with? I didn't sign up to take a photo with anybody. Because you know what, bitches? People are going to want to fucking take photos with me. Okay. Anyway, let's see. They don't tell you who is going to do it. Okay. I don't know. All right. Anyway, that's where it is. And that's what it is. And that's all it is. And that's all there was. And let's see. What else? So that's going to be fun. I'm going to start at 9 a.m. Pacific on that Saturday and then go as long as I can go. Dressed up. I have to make this costume. Let me get to where's the costume again? Yeah, oops, no, that's not it. Did I? Oh, no. I have to figure out how to make this. So what I was thinking was white tights, right? And white shoes. And then like a fabricated cylinder, for my body. Like probably out of that white, stiffer material, but that really holds its shape. And then just fabricate it as a scroll of paper, but like up to my neck. Because I want to have periphery vision. So I was thinking I don't want to do like a face cutout because I won't be able to like see side to side. And you know what? When you're me, you gotta have your head on a swivel. I got a lot of enemies. Anyway, so I'm thinking of like a thing that goes up to my thing where my arms can like hang out, but I'll wear like a white, and white gloves, right? So I'll be like, and then obviously all the accoutrements, les billes, les placards, les ribbons. And then I was thinking of a headpiece, again, made out of similar material, or like almost like a chef's hat concept, but maybe not. Maybe more of a hat with like the same shape cylinder on the bottom. So it's more of a serious headpiece because I wanted to make an impression of the scrolly part, this scrolly part here. And then I was thinking of kind of figuring out like the googly eyes of doing my makeup. Not similar, like exactly like this, but somewhat to convey this expression. What do you guys think? I'm really excited about it. I know. I love it. Oh, bye, gal. See you later, alligator. Oh, my goodness. Anyway, yeah. Fourth season of Stranger Things. Oh, he really does have a great voice. He really does. Yeah. I know. Well, and I probably will trip over them and not know who they are, but that's okay. It'll be fun. And the rat tour is in Tulare. Sorry. Jen, do you want to dress up? You want to go? I don't know how much tickets are. Gal, do you remember, if you're still here, Gal, do you remember how much the tickets were? Because they make you text them to inquire about tickets. It's like this super secret thing. It's really weird. And so I don't know. It's going to be fun. I'm really excited about it. And then what I was thinking of doing was, as I'm streaming, walking around and bye gal, walking around and like, you cats, you have to do a better show. This is really, you're really dropping the ball, divas. What was I saying? I don't remember now. Well, anyway. Oh, Tulare. So I'm thinking I need to contact them and buy my ticket. And I'm really just going to go there and observe. I mean, I don't have any other. I'm not there to make trouble. I'm not going to dress up as a dinosaur. I'm not going to do any of that stuff. I'm not trying to make a show out of it. But I will be recording because I want to document what happens. But I do want to go to that. But I do have to figure out how much it is. So if anybody knows how much it is, I just need to figure it out. Oh, here we go. Here we go. People are talking. People are talking. People are talking. Let me get rid of that. People are talking. No, they're not. Do 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 do. I'm gonna have to pee. I might have to pee. We could fly your drone over it. Oh my god. Can you imagine? Flynn. I know. Yeah. I really want to go. I really want to go. Really curious. I think it'd be fun. I mean, not fun, but like to see some of those people in real life would be kind of interesting. Because you spend, as you guys all know, some of us and some of you spend so much time listening to certain personalities and trying to understand what their connections are and all of that good stuff. That to meet them in person would be like, okay, this is some closure. It's like, now I have closure. Okay, that's great. I'm great. That's great. Yeah. Anyway, let me find this. I think they're going to be a minute. Wait, what time did they get back? In 20 minutes. All right. Well, I'm going to find us a fire to watch then. Because I want a fire. I want a fire. Why don't we have a fire? Boop, boop, boop. Boop, boop, boop. Why does it always sign me into my Laughing Lola account? Isn't that weird? Campfire. Camptown races 5 miles long. Doo-da, doo-da. Camptown races sing the song of the day. Gonna run all night, gonna run all day. Sorry. I was just really silly when it comes to this shit. Hold on. Nobody wants to hear you yet. Nobody wants to hear you yet. Go down, lady, sing the song all the day. Here it is, it's just a campfire, it's just a campfire, it's just a campfire. Please hit the like button. Whoops, I didn't mean to do that. Please hit the like button. I think I could, and just do it and approach it in a serious way, so that you're not, I'm not there to be the scene. I'm there to observe and understand. What the fuck is happening? Do, 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 do. There's a bit around. Wait, what? Did you see the guy who believes that no. Come on, no. No. Stop. It's a tough world right now. Man. Take care of yourselves. Be gentle with I had a person say that to me, like, how we say stupid things to each other. But I had a person say to me, be gentle with yourself. And I'm like, I've never forgotten that. I feel like it's such a great, like, okay, yeah. It's a good reminder. Just to stop. I also had that horrible boyfriend who was like super abusive. But the one thing he once told me, which I thought was it was weird because he was saying it in a really mean way, but then I always just twisted it in my mind and went, oh yeah, that's actually not a bad reminder. He'd be like, would you just put your head up and look around right now? That's what he used to say to me. And so sometimes when things are really weird, I'm like, just put your head up and look around right now. And it really is a weird, like, I've twisted it into something positive. probably says more about me than anything. But yeah. Do 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 do. $250 for tickets. It's for the cause. God, so there's like really like probably rich people going to these things. Yikes, $250. That's like 4 times Comic-Con. Am I going to get any interview? Am I going to get autographs? Do I get a photo op with Mike Flynn? Is he going to sign a poster? I should bring a photocopy of his pardon and have him sign it. Actually, I should bring photocopies of all their pardons and just have them sign it. Here, can you sign this for me? I'm a fan. Who knows who I'll see there? Aren't most of the official participants of MLMs? And aren't most of the official I would, yes, absolutely. I mean, the whole thing is an MLM, really, right, Max? I mean, the entire thing. See, that's why it's fine to refer to everything that one might think is a conspiracy, but at the same time, all one has to do is look at the advantageous, who is advantaged after certain actions are taken. And it doesn't take conspiracy or coordination or any of those things to identify that behavior as wrong. And so when we observe blatantly wrong or provocative behavior, it's okay to call it out. That's okay. But yeah, no, I think it is an MLM. I think obviously there are true believers, obviously, but I'm not convinced that any of the people we frequently talk about or identify as architects, I don't think many of them are true believers. I think they see an end goal and they see a means to an end. And it's almost like a stock market, when you watch the stock market reactions. Now, granted, those are like institutional trading, but put that aside for a moment and think about how people try and anticipate the movement of the market. I think in many ways, these architects try and anticipate the movement of their base as a market. And are their shares going up or down? So yeah. Oh, Siegfried, hi. How are you? Good to see you.
Like those shoes.
I don't know.
Couldn't find those Adidas, right?
I don't know. It's a good question. I'm sorry, Siegfried. Well, there's a little more to come, it sounds like. So they're working on modifying the bond order. And they're going to argue about language, I guess, in a minute. I'm not really sure. Did we hear a defense witness? Now I forget. Did we hear a defense witness? I don't even remember.
$6,107. Love what he looked.
Anyway. Would have been much better. Oh, babe. I'm sorry you weren't here, babe. We got you. This is a much nicer moment to come in with the fire. Otherwise, it's been pretty poopy stuff this morning. Yeah, I woke up really late. I'm like late girl today. I need to shower and stuff like that. But tonight's the movie. Tonight's a movie party, pajama party at Lolo's. Yeah, we're having pajama party tonight for members. We're going to be watching Planes, Trains, and Automobiles, and we're going to be watching it on the big screen TV. But you just have to come to YouTube. You don't have to go anywhere else because it's a members only. Bleep bleep. So just click into this channel. You shouldn't have to do anything special. And you can join in the moment, actually. If you're not a member already, you can join in the moment. I know, I feel odd saying that, but this is where we are, so let's go ahead and say it. But I am thinking of transitioning out of membership so that we can just all, as a community, do the things that we like to do. But at the same time, I'm also trying for those people who do have memberships to give them something unique and different so that they can experience it. But I also miss that some people, and I don't want it ever to, like, you know, anyway. So I'm thinking of ending the whole membership thing, and just doing movie nights for all of us. Because I just really, I think it's such a great group of people. And I think that as much as you guys are, you know, find me funny or whatever you find, or aggravating, whatever the word is that comes to mind. I think as importantly or more importantly, and that's great, is that you guys connect with each other in the chat. And I really think it's a very beautiful thing to witness when people connect with each other in this way. And as all of us have seen different chats erode over time, I'm really grateful that this chat has been like to get just so adult and so grown up and here for the right reasons. And, you know, I don't know. It's just a good group. It's a smart, fucking smart group of people. And nice. And there's a lot to be said for just having a really nice group of people to be around. Well, thank you, Siegfried. That's really sweet of you. I really do. You guys are amazing. And we're going to do more. I'm feeling a little bit of the heat this weekend, but we're going to move through it. As the way, I love this gang too. I love this group. Truth though, my minions are trying to. Yes, yeah. Then there is that. There is that. I don't know. Oh, you are all the best. It's really it's a fucking smart group of people. And it's growing. And that's beautiful. And I love that. I love that about us. I wish we could cool the heat. Couldn't we just cool the heat? Can't we just cool it? Cool it, people. Cool, real cool. Do-do, rocket in your pocket. Be cooly cool boy. Do-do-do-do-do-do-do. Wait, I used to know that song. We used to sing that when we were kids all the time, my sisters and I. I mean, just because we like that musical.
Tomorrow.
Be cooly cool boy. Where's the lyric? Here we go. Boy, boy, crazy boy. Get cool, boy. Got a rocket in your pocket. Keep coolly cool, boy. Don't get hot, 'cause man, you've got some high times ahead. Take it slow. And daddy-o, you can live it up and die in bed. Wait. Boy, I kind of lost the tune there. I apologize. Boy, boy, crazy boy, stay loose, boy. Breeze it, buzz it, easy does it. Turn off the juice, boy. Oh man, go. No, go man, go. But not like a yo-yo schoolboy, just play. Wait. But not like a yo-yo schoolboy. Just play it cool, boy. Real cool. You're welcome. You come here, you get a campfire, you get justice, and you get a recreation of everyone's favorite musical, West Side Story. Come on. Hit that like button. Jeez. I'm not, not on tune, but nonetheless, a cold read, if you will. rocket, and then punk it. Did we get a judgment? Not yet. I have the sound up. I guess that's a way of changing the. Is that your way of changing the subject, Max? No, Steve. There's no judgment yet. And we're live. We're live. That's Stroll Go. That's Stroll Go. Got a rocket in your pocket. Be coolly cool boy. Do. What more could you ask for? Because when you come to your television, you don't know what you're gonna get. God, I hope I get it. I hope I get it. And then what happens? And then this happens. I'm trying to make edible cornbread for Thanksgiving. What do you mean? Wait, what happened? I just spent hours trying to make all the. Oh, sorry. I'm so sorry, Siegfried. That's a tragedy. Oh. Well, good for you for foraging through, pushing through, as they say. Good idea. Do you guys see my beard? I have a beard on. No? All right. Oh man, that was a terrible idea. Let me just tell. Oh boy. That was a horrible idea. You bought some more weed to make more. Good for you. When in doubt, buy more weed. I have been, okay, I've been buying these because they're cheap. But man, I smoke them so fast. I'm like, is this a half a gram? And I'm not like paying attention. No, it's a gram. I don't know. I can't explain it. I can't explain it. God, I just don't know. I don't know how you guys do it. I mean, I suppose your beard hair doesn't fall like into your mouth and, you know, that. No, it's probably the burn, right? It's probably the burn. Got a rocket in my pocket. Be coolly cool boy. Don't let go. And Scooby Dooby. Scooby Doob Doob. That's why I try to make. You know, the thing is I really need to try this. I need to try that. And I also would like to do that. Tastes terrible, burnt, excellent weed. Yeah. It does fall into your mouth. That's unfortunate. I mean, how often do you have to like trim it so it doesn't get in your mouth? How often does that have to happen? Does that have to happen like every day, or like twice a week, or once a month? Tell me, bearded men. Talk to me. Make it make sense. If you think boiling in water. Oh, I remember you talking about this, Max. I remember you talking about that. It's not that hard, but there are too many conflicting ideas. Yeah, I agree with that. I mean, we've had this conversation a number of times. Yeah, that is true, Max. I think we had that conversation last time. I remember when we talked about how to make the edibles, and then we laughed because I put too much sugar in something. Wait, what is it? What did I do? I remember ruining something we were cooking. Oh, guess what? This Friday, we are doing a special room 206, Lolo's Lounge on Spaces, to do a post Thanksgiving holiday Super Jim and Lolo trivia on Spaces. We'll probably simulcast it on YouTube, but we're gonna do that. Wait, I need to catch up with the facial hair conversation. Hold on. This is not facial hair conversation. After you put in the fridge and later skim the butter off the top. Okay. Wait. So are you heating? Wait. Are you heating the cream? No. Are you Okay, so you're heating the butter. I see. I'm so sorry. I'm thinking about making. It could be hair from anywhere above the mouth. I try not to think about it. Kittens, puppies. I got you. Okay. Fair enough. Fair enough. Do 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 do. Facial hair would suck. I know. Siegfried, we need a Max Flower. That's right. Happy things. Ganja butter. Yeah. On a really nice piece of like, you know, that bread that you get from the bakeries that do really good, like 7-seed bread, and it's really beautiful and like sprouted and really yummy. And then they slice it and they make toast. Can you imagine putting like yummy weed butter and a little bit of like blackberry jam, like just a little teeny tiny bit of blackberry jam? Girl, I'm in. Sign me up. Marry me. Make that for me and I'll marry you. But then you'll have to continue making it for me. Boiled removes too much THC. Better to simmer. I see. Okay. I do. I have a fair amount of cat hair, but not terrible. Not as bad as I thought it would be. What is going on? Everybody's pooping. Everybody's pooping except for this guy. He's gonna draw on. Is that a chalkboard? Is that a chalkboard? Or is that just the wall? Oh, it's just the wall color. I think. I'm very confused. This guy's like, I didn't get to poop. I didn't get to poop. Why don't I get to poop? Oh, these people aren't pooping either. I didn't even see you guys. Is Lisa Rubin there? Where's Lisa Rubin? Or wait, who's down there? Now I can't remember who's down there. Where's the Atlanta Constitution Journal? Is that guy? Is that guy? Is it 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 that guy? Hey, you're not supposed to be sitting there. All right, they're clearly not at back yet. Okay, simmer. 3 hours. Filter cool. Yes. Okay. Next. Ooh, you know what? The crock pot's a good thing. The crock pot is just a good thing. And you can get one at like the like CVS or something. Chalkboard. I know it's not a chalkboard. It's not, obviously. It's in my eye. Doctor, my eyes. Tell me what is Anna. Thank you. Anna Bauer. Thank you. Anna Bowers. Is it unwise to leave them open for so long? Oops. What did we miss? They have them at Walmart for $10. $10. Yeah, they really aren't. There's some good pricing on them. And they come in handy. Doctor, my eyes. Oh, this is good to know. THC burns off at 311 to 320, so boiling is safe. Good job. Thank you, Max. Thank you, Max. Thank you, Max. They are coming back and everybody's sitting down. Hey, you just win the Masters.
I'm gonna handwrite it out. There's only people that ask for court orders. It costs money to get them cards. I haven't used one in 10 years.
Cards.
See?
Them cards.
Huh?
pretty soon people will say, yeah, QR code. That's a good idea. I should put a QR code on a business card.
To decarb, which I forget. Oh my goodness.
Yeah, who doesn't nowadays?
I'm loving the card thoughts.
Or
There
mine.
you go. Elvira. Elvira.
I bet you're going good.
My heart is on fire. For Elvira. We can try to make any song sound reasonable. Yeah, it's fun to learn. It's a little, yeah, it's a little expensive. Yeah, that's a really well put. It's fun, a little expensive. Butter's expensive. Joe Biden. Ugh. Damn you, Joe Biden.
I forgot to put the name of my firm, so I'll put it down below. It's the name of the firm.
My heart's on fire.
It's not my fault. Catch you on. KACHOUR. Are you the court reporter?
The whole day through.
Oh, okay.
You can say yes right away.
Thank you.
The whole sweet song keeps Georgia.
Can you thin me out a little bit on the photos?
On my
Can you thin me out a little bit? Okay. Hey, how?
Georgia, the peace I know. I don't know the words.
And she won't, you know.
I mean, that's such a problem. What she came here and this was
Oh, smile tenderly.
Really? Because it's red. Let's go back to green. I can get to go green.
There it is. It's supposed to be green? Yeah, it is now.
You're talking shit.
It was on red.
Yeah, it was. It's red is on. Green is on.
It was on.
It was on red. Yeah, it's been red. That's that one.
It's okay. You just go back there. You tell them I said what I said.
Wait, did I sing over
red is
something
on.
important?
Okay.
Did I sing over something important? What just happened? I'm so sorry. What did he just say? Wait, what did I miss? You guys, what did I miss? I'm so sorry. You should do phone or video. That's what I had when I got my medical marijuana thing in New York.
He was texting me the whole time.
Oh, it was COVID though. Oh, really? That blows.
I knew it was good.
I just say it.
160 to 260 to keep the room.
As soon as I get back to my phone. No.
Wait, what did he say?
Oh, there we go. Oh, no, it repinged. It just wasn't ringing again.
This THC workshop we've got going on here. Yeah, you're right. You're right, Siegfried. I forgot. That was COVID.
I was very lucky.
That's a lot of money.
That was most of the honor.
Just all that you got.
So thank you.
God, it's 2:06, but I kind of want to run back and hear what he said. It's terrible. It's dumb. That's what it is. You need a 6-month visit for your Pinot Grigio habit. Cheap here in Missouri, just like Missouri. Oh wow, interesting. Isn't it great that we're the United States of America, but every state is different? I need to hear what he said.
It's not something I think I've ever heard.
It's a good group, smart group.
So does that show us
It's gonna be easy with law school.
Hey, it's not me.
I need a banana nut muffin. Banana nut muffin. Because I didn't eat any breakfast. Or lunch. Is it lunchtime? Oopsie. Banana nut. I really like the edible capsules. Oh, really? I haven't tried the capsule thing. I haven't tried those. Does anybody know what this doofus said? I swear to God, if he said something really stupid, and then they come back and go, dude, we just told you, and put him in jail, right to jail, right to prison. Right to jail. Right to prison. Yeah, I mean that. I would like to eat something that isn't like smoking, you know what I mean? Like, that isn't like this. Although it's still flavored. You can turn off your microphone finally? Ooh. Turned off the microphone? What? Oh, you know what? I've heard about that. I've heard about states doing that. Gotta love low tolerance. Oh, hello, Mr. Gustafson. How are you today? Are you gonna come and visit? Go ahead. You're fine. You can do it. You got this. Christopher Gustafson is here to say hello. Hello, Mr. Gustafson. He says, I'm making my way over to my nap place. Thank you very much, and don't interrupt me. Don't interrupt me. I don't know. What is the whole pooping? Christopher Gustafson. Yes, Mr. Gustafson, what are you doing? Oh, you're sitting with your face in the rope. That can't be very comfortable. There you go. You're getting too big. That cat is huge. Can I just tell you how big this cat is? Oh. Jen, wait, what happened? Nice to wait. Oh, Jen, I got you, girl. What's up? I'm so glad you're here. Does it really? Man, I think I must have like the highest tolerance ever. Jen, we got you. You're here now, Jen. Got you, girl. Then street weed, the THC percentage. Yeah. Is it? I was gonna. Although I haven't had street weed, so I don't really know. Probably not since like 1982. Yeah, or 83. Anytime before 86, because I think I pretty much stopped smoking weed after 86. I had other vices, like Chardonnay. Gustav, where are you, Gustav? Where'd you go? Oh, he went up in his little like cave. I see his little paw. Do you see his paws? He's so cute. He's sitting in the sun. Are you sitting in the sun? He's like, shut up. Oh wow.
I know. I've been really saying that you want to cover it, but I put you cover the actual trouble.
Oh,
So it's respectable.
okay then. Oh my God. I would say so.
They all
Well, I say.
one thing I say.
Christopher
I'm gonna allow to talk about it. Okay, yes.
Oh no.
And one thing I learned about this.
Well, thank God there were people around. Make it bigger so we can see. I know I want to, but I don't know how to do that. I gotta, you know what I'm gonna do? Oh my God, you know what I'm gonna do, Melissa? Or wait, Jen? I can't see anybody. What I'm gonna do is get a kitty cam, and I'm gonna put a camera on the, you know, on the kitty tower. And we can keep an eye on him. I hope he's okay, Melissa.
Yeah, you feel my come past the bar.
I got too much. I was trying to do
After we finish, I
Oh, you
can't
were.
wait just to eat. I'm so hungry.
I was waiting for you to chime in.
Stop and then a muffin on my fingertips. Mm, mm. Yeah, I gotta like get ready for tonight. So we're gonna watch Planes, Trains, and Automobiles. Just if you're not already a member, hit the join button. It's $1.99, which is less than one of those like pepperoni sticks at 7-Eleven. So come on, where are you gonna get all this great, content? Except for right here on Lolo's. With the most amazing chat on the interwebs. I'm getting a banana nut muffin on my phone. Yes, I really want. I mean, I'll attach it to the cat condo, but I think I'm definitely going to do it. I think I definitely want to do it. Kitty cam, and then because it'd be nice to have the cats on camera. Vape pen. Get the teddy bear. You need the bond. My daughter looked at this and went, "What is that? A bondage bear? What the hell?" I'm like, "No, this is Teddy, and he's a vape pen. Don't be a hater."
I was raised in church.
Yes. Oh my God. From when, the 60s or the 70s? That's awesome. That's a great movie. That's a great movie. I'm not putting a cam on the cats. Oh hell no. I'm not doing that. I don't want to see that. Nobody needs to see that. But bondage bear. I'm like, that's so weird. But I mean, I guess I see your point because it's wearing like a little mask. So I guess I can. And it's like, but it's just, I think that's a striped sweater. I don't think that's bondage. Whatever. Oh, we should. That would be fun. That would be fun. Funny movie. It's really fun when they get up there and play because they're very funny. Cat butt cam. It's a cat butt cam. It's time for the cat butt cam. Where your minds go. It's a cat butt cam. It's a cat butt. We just know what our animals are going to do. That's all. They written, hey, wait a minute. So I'm a little unclear on this. Okay, somebody help me out. If all of the defense counsel is sitting there, then they're not really negotiating anything, right? Like it's just Bonnie and her team are going back and revising and being more specific and coming to them in court and saying, this is what you got. Goodbye. But I want to know if he just violated the order again. Has anybody been on his social media?
My wife and
I don't want to find his.
Yeah. Hey, you guys know if you want to talk outside? How you thinking?
This is his current Twitter. I'm gonna follow you, baby. 29,000 followers. Thank you for all your prayers and support. November 17th. More of this. And I'm proud to be an American until I sell her out. Then I go and buy a car so I can drive and shout. I won't proudly stand up next to you. Either you are or you aren't. Here I am holding somebody's child. Oh, I served the country, people. Look at it. I served it. Come on. Love me. Love me. Love me. What's this all about? What's the point here? What's this picture? Who's that? Who the hell is, what's this? What is that? Who's that? Is that a duck? What's that? Is that a trombone? Is that a cello? Is that the Slender Man? Sure. What the hell? Is that a lion? Is that a bird? Fuck is it? What's that? Is that a turd? Who is that? Is that the famous actor Harry Dean Stanton? I'm confused. I remember. Very confused. He was in Iraq with a broken finger. Famous broken fingers. What did Harrison do? Yeah, it's Harrison Floyd. Back hurts. My back hurts. I gotta walk around. I'm gonna have to take a jog or something after this. All right, never mind. Nobody panic. Everything's fine. It's a minor. Oops. Muffin down. Muffin down. Muffin down. I liked my description of this cover photo, frankly. It was like a find it, one of those hidden puzzles. I got you, Harrison. Very clever. Very clever. Ooh. He's not proud to be an American. And he bullies ladies and men.
Yeah.
People's brains are gone. My brain's gone. They're really trying to work it out. Oh. I really want to know what he said earlier. I'm just afraid to leave it and then rewind. I should have made a note of when that was. God damn it. Well, it would have been, let's see. I think it was around 2:06, so it was about 18 minutes ago.
What's that? My shirt is trending.
So if it's 4 hours, it's about 3 hours and
No, yes. My jacket.
40 minutes into it.
My jacket is trending. I let him borrow it.
Sustained.
What's it trending in?
Sustained.
Lucky Charm. Lucky Charm? That's nice, that's dope.
Yeah, that's better.
I got some more, don't worry.
Yeah, we can't say anything this is loud.
Yeah.
I'll try and find the hot mic clip of what we missed. I know, he's such a slime ball.
Yeah,
Okay, so but here's my thing, you guys. Here's my thing. He knows exactly what he's doing, right? They're definitely playing the angle. If you read any of the positioning of MAGA on this particular hearing, it was very clear that the messaging is he's being picked on because Fonnie Willis is being racist against him as a Black defendant. So that is what they're hanging their hat on, the fact that this is a racist revocation of bond, and he's being singled out and treated differently than other defendants. So, but we'll get back to that. And I am so grateful to have been able to see her in action, because I do, she's masterful. Because she knows this case backwards and forwards as the fucking district attorney. She's not leaving it to everybody else to have all the details at hand. I'm impressed. Because she's had to prepare for all of those other hearings and motions and all that other bullshit. I don't know. I just think it's really showing a lot of hard work and dedication to doing the right thing. And that's, how lucky are we that she's doing it on our behalf. That's pretty cool. And subjecting herself to a lot of hatred and threat. She didn't have to bring the trial. She didn't have to bring the case. I don't know. I'm grateful. I'm grateful. I know. I'm really excited for now her to be in part of the main trial. I don't know. This kind of stuff is really interesting to me, and I'm really sad we actually didn't restream the appeals or the appellate court in New York hearing the gag order information yesterday. I just woke up too late to start streaming it. But I will be on the lookout for that, because I do subscribe to some of those appeal courts, their YouTube channels. So I'll be on the lookout for those, because I would like to listen to those with you all too. I think they're very helpful. And that one was really good yesterday. But I unfortunately found out about it too late to start streaming, and I wasn't sure how long it was going to go. But we'll try and prepare for those. It was better good. Which was quite good. I just like it when people have an understanding of the subject matter, and to hear people who really do have an understanding, or various levels of understanding about the subject matter, is very fascinating. And it's equally fascinating for me to hear the arguments. Like what is being argued by Harrison Floyd's lawyers, right, in this setting, or the lawyers yesterday on behalf of not pursuing a gag order, the Trump camp. So I find that fascinating, because I want to understand, because I feel like if we don't understand what the actual argument is, how can we convince anybody that they're wrong? How can I convince someone they're wrong if I don't even understand what their argument is, or what their values are, or what they care about? What's their skin in the game? I feel like I have to understand a little bit about that before I'm going to try and, right? Like that's pretty standard stuff. Not that you have to spend an inordinate amount of time listening to it or lift it up or anything like that. I mean, granted, we do that in the course of analyzing it or making fun of it. But the intention is to analyze it or make fun of it. A little bit different. A little bit different. Yeah, just a little bit different. And here, and so I face the final curtain.
Calling out, come on, remain seated.
Yeah, maybe they did.
Okay.
Yeah. It was breaking our thinking. I agree, Max. I know.
All right, we remain on the record, and I've been provided with a proposed modified bond order for Mr. Floyd.
Were you also provided with what he was saying in the courtroom
by the state? And was there anything for me to review from the defense?
Yes.
Yeah, here you go.
Okay. Can we get an extra, do we have an extra copy? Can we print off another?
Sure.
No, well, yeah, I haven't seen those. If we could give the,
Can somebody play the judge the part where the guy
I
was
think
talking in
there's
court and was told that he
a
was
good
on the
bit for the defense to consider and digest here. But I don't have a copy. Well, the state's looking at the defenses right now. Okay.
So what were you doing during the break, except for making copies? Do 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 do.
Yeah, take.
Oh, agreed, Jen. Agreed. Agreed. Yeah, I agree. I agree. I agree. I agree. I agree. Ah, yes, Lee.
Did the defense get a copy of the state's proposal?
That's what we do here at the
Okay, that's going to take a minute to review.
Take
So
a
while you're
minute to
doing
review.
that, then we can
Why don't
might
we
still
go
just
over what
need
was said in
to-
the courtroom during the break?
wait until we can actually discuss this in depth for a few minutes here. But I'll just note for the record, the defense proposal here is handwritten that says no tags, no DMs, emails, texts, or calls. No Ruby or daughter, but can respond if Ruby says something about Harrison. State provides a comprehensive list of witnesses, but Harrison can respond if mentioned by a witness. No statements by the state that criticizes Harrison. Okay.
Okay. What? Your Honor, my client and I respond, nuh-uh. May it please the court, nuh-uh. She's like, I have drinks with my friend scheduled and I gotta go. She's like, I gotta get out of here. Everybody's reading, 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 reading. Harrison has to poop. Harrison has to poop. Hey, who's that guy? What's the guy? That's the guy. Is that Cheese Bros lawyer? Is that who we identified earlier? That's the guy who I wanted to know who he was. Who is he? Who is he? Let's see. What's a good song for this portion of the broadcast? I was thinking something with Ruby. Brandy, you're a fine girl. What a good. I can't think of any other song you would be. I used to love that song when I was a kid. Got a girl working at bar. I don't know. We'll dig into that later. What a girl you would be. But my life, my love, and my lady is the same. You
think we want to dive in?
There we go.
I think we're ready.
Okay. All right. Well, let's use the state's modified bond order as our working copy. And we can just try to go through this
Fast.
paragraph by paragraph.
Oh.
As I read it, 1 through 9 on the first page are essentially duplicative of the original bond order. Any concerns with 1 through 9?
Yes, specifically I don't believe number 2 and number 5 were included in the one. Those two are different.
Or what? Oh,
There was he has to report.
She
I
gifted.
don't know if I brought my original copy.
Lolo's Lounge membership. We're doing the gifted membership dance. We're doing the gifted membership dance. We're doing
Yeah, that one does seem
the
familiar.
gifted membership dance.
Okay.
Thank you, Siegfried. You're love. You're in love. If you go up and click on the gift and accept the
Number
gift, you
5.
may be the lucky recipient of this beautiful 1 month membership at no cost to you.
Sure.
Thanks for supporting, Siegfried. I appreciate it very much. Very, very much.
The issue goes to the should be, well, we obviously, we don't want to make statements that
I think it's be good to have songs for every special.
one way or the other. That's the intimidation one, that's weird. I think that no contact rules.
Don't worry about it. Don't worry.
The president were to call him. You couldn't talk to the president because this would be a no contact order. The president's order doesn't have no contact. I think there needs to be some kind of carve out.
Oh, is he referencing the order from March?
Hold on a second. Just remember, y'all, we're on the record, and so we need to make sure that we're speaking into the microphone because our court reporter is
I
remote.
couldn't hear anything you just
Okay,
said.
so just to note, so originally we had as shall not communicate in any way with any person known to be a witness
Don't
or
worry,
co-defendant
you guys are
except
great.
through
I love
counsel.
you all very
So
much.
now that has essentially kind of been consolidated to make it very, very clear that it's just no contact with any co-defendant witness or anyone specifically named.
And we believe this is in Defendant Trump's motion, if you want to pull it as part of your record, that
Mr. Floyd, it's not your turn. So it's in the co-defendant's bond order.
it is in the co-defendant's bond order.
All right, so
Ooh,
Mr. Kaczmarov, is there a specific
Mr. Kaczmarov, what do you say to that?
witness, co-defendant, or person named in the indictment that you think there should be a carve-out for?
First of all, for those respecting counts 30, 31, for sure. That would be Stephen Lee. That would be Trevion Foodie. Indicted co-conspirator number 23, who we believe to be Harrison Floyd.
All right, but just so I'm clear beforehand,
Remember, it was no direct or indirect communication about the facts of this case. This is absolutely no contact period.
sure.
So that's the difference.
And so you're saying that the difference here and what's needed is that Mr. Floyd should just be able to casually keep in touch and stay up to date just on a social level with these 3 individuals?
No, I mean,
If it's not about the facts of the case, I mean, were they personal friends before this
Yeah,
indictment?
he's not seeing what you see.
I don't understand the difference now. No contact versus communicate. What does that mean?
I think it's just making it very explicit. No contact.
Well, that wasn't in there before.
Great, why don't we
That
put him
wasn't
in
any part of
jail
the
when he can
allegations
think
of
about it?
And I would object to that going in. I think that's just a bit onerous for the occasion.
Well, onerous in that, how does it change what he's already been doing the last, what are we now, 4 months? I understand your point, but what I'm saying is
It's communication contact. Because if it is, we're being duplicative in the court order.
I could say there's, sure, I could see that there's some overlap
Charlie
with
was gifted a
5
membership. Hello,
and
Charlie
It's a
Cheswick,
concern, like, you know,
Libertronic.
to be contacting Ruby, fine. Don't contact Shay, fine. I don't have a problem with that. We're not interested in contacting those 2 folks.
Your Honor, may I speak? It is typical in bond orders that co-defendants are not allowed to contact each other, and they are clearly co-defendants in the case. And so this is not an unusual request.
All right. Sure. Noted, but it is a very standard condition.
But he's starting to
and-
date
and-
Mr. Trump. You don't understand, Your Honor. You can't stop
I would say
love.
safe to say almost every single case. That being said,
You can't stop
I do wonder, is
love.
there any need now to have 11, 12, or 13?
You guys are too sweet. I love
Or do we
it.
think 5 pretty much swallows those?
I'm grateful. I'm grateful.
Your Honor,
you're
we want to
here.
make sure there's no misunderstanding here, and so we'd rather you make it perfectly plain. If you think it's unnecessary, I certainly don't want to be back here in 2 weeks because it was unclear, contact, communicate. So we think both adjectives are necessary since
All right, Mr.
It's
Cottrell.
like, go ahead.
It does effectively muzzle him from saying anything. Nothing about the case whatsoever. I think that's not appropriate. I think understand what the
Okay.
issues are. You can't,
Dude,
you just have to even say anything on social media.
Well, where do you see that? So now I guess we're getting more into the more substantive new additions from the state.
Like number 10.
Number 10, we have,
And the contact condition as well. The defendant shall make no public statement of any kind concerning any co-defendant or witness in this case or concerning any person specifically named in the indictment.
yep, that's what I
Beyond
wrote.
witnesses, including himself, maybe. That's the other part of this. This shall include, but is not limited to statements in books, statements in newspapers, statements in magazines, statements on television, statements on radio, podcasts, YouTube, film, or any other commercial or self-published media. I think that's not appropriate. I don't think that's not designed to remedy what they complained about originally.
Really?
I handed you a list that I thought was the short list, because that's the remedy that we thought the court would employ. So I have a problem with that. And then the second one is,
Dude,
number 14, it's just way too restrictive
way too.
condition.
And that's a legal
Yeah, this
term,
says
Your
about
Honor.
condition.
Way too.
But the defendant shall make no social media posts of any kind, whether public or private,
What?
concerning any
What about
co-defendant or
those
witnesses.
private
I think
posts?
if we just had the original order, you can add the no physical contact with any witness, that would clear that up. And the communication part, you can add in no collusion with any witness, but in terms of him and in the list that I suggested to you, you say nothing about Ruby Freeman unless she has a few lawsuits pending. If she were to say something, I would of course vet whatever was going to be put out there with the idea of being able to
Really?
respond.
You're doing great so
If
far.
doesn't find it to be true, or he finds it to be true, or what have
Yeah,
you. So
DMs.
I don't think 14 is
Oh, yeah,
appropriate.
did they not say DMs?
So restricted
Direct
on social
message?
media.
and again, give me specifics. What is it exactly that you think he
Direct
should
message.
and wants to be able to do
Yeah,
that
what does
14
he wanna
precludes?
If he wants to get interviewed by a reporter and
Oh,
talk about
that. Thank
how this case
you.
came about, what he did in this case,
Thank you.
I can't believe the district attorney would object to that. They'd probably watch it, catalog everything he said. Or if he wanted to get on social media and say,
And the bondage
Ms. Willis
tag, he
is,
says, thank you,
not a nice
Melissa,
person,
for
she
the
did this, she was
gifted lounge membership.
if he went on there and said, what she said about me in this case is not true, or what the evidence that I've seen on the internet concerning X, Y, and Z is not true, he should be able to respond to
Let's
that.
see who got it.
Otherwise, you're just muzzling him and stopping him from talking at all. That's what the
Free
state's really
Rob
does.
was gifted
You're-
a membership.
Ms. Willis?
Free
Your Honor,
Rob was gifted a
this bond order
membership.
does not mention District Attorney Fonnie Willis at all. I've stated on the record, he can say whatever he like on any post he like about me. I have no value for what he says, and I'm threatened every day anyway. So that he posts and I get threatened some more, that'll be what it is. I've learned to live with that, and I am a public official, and the voters elected me here, and I put myself in this position. That does not give him the right to contact co-defendants
It's your
or to
membership
intimidate other witnesses.
anniversary.
And quite frankly, it's really in the defendant's interest to shut his mouth about this case because it can and will be used against him.
Anniversary.
Should be complaining.
We're doing the membership.
The complaint is the harm that it does to the witnesses and the victims and the community.
All right, we're going to take
Three
turns.
months.
And the one thing that flagged to me, though, was whether this is going beyond the facts of the case as well, because one of the conditions here in 10 is shall make no public statement of any kind concerning any co-defendant. And so essentially, does that mean the expectation is Mr. Floyd, who apparently wants to be a very active voice publicly, does that put him on the sidelines if he wants to participate in dialogue about the 2024 election? Is that intended?
Are those the facts of the case?
Because
The
one of
2024
the
election
co-defendants
is
would
not
be a
the
candidate
facts
in that
of the
election.
case.
And if you mention the 2024 election, is he not mentioning that co-defendant?
Like to add the sentence, he can promote defendant one as a candidate.
I guess what I'm getting at is before it was tied to kind of the facts of the case. And so it seems like we've gone a different direction in this one. And what we can also do is again, this one is more of a broader order. If we need, I would feel comfortable signing this right now as a provision to get us through today and through the foreseeable future. And if we need to come back and consider argument to modify, we can do that. I don't really see the harm in having such a blanket restriction in place for the next week or two.
Your Honor, the only thing that we would ask, because we want to make sure that they read it, is in exhibit number 16, provision number 16. That is something affirmative he needs to leave this courtroom and do. 12 hours, we believe, is generous. I don't see why it can't be done in 30 minutes, but we wanted to do that. I wanted to bring 16 to your attention.
We have no problem, although 12 hours is a bit extreme since he lives in Maryland. He's going to be traveling for the next several hours to see his family. We've got the holidays coming up. You're not going to have any trouble with that, Your Honor. He's going to be deleting those posts. That's not an issue for us.
Well, I mean, theoretically, he could just go in the next room and it doesn't take very long to delete a post.
In the car.
Okay, but
I wasn't sure.
yeah, I don't think deleting a post is all that onerous. So bottom line, am I hearing there's no defense objection to 16 as written?
I have no objection.
Okay. All right. I think that, again, I too often I think we run into problems when if we all collectively are rushing. So I'm fine to sign this as is today, and I would be happy to entertain a second modification once we've been able to digest this, to consider it.
iPad
And
right.
we can either hear argument, or we
Good
can do it through
point.
briefing, or we can even just do it through email. So,
Judge,
sir.
why don't we just have a one-line order until the next hearing? He stays off social media period until the court has a chance to.
Well, this goes a lot further than just social media. And again, I think this is a comprehensive order. But I also still want to respect the general, again, like as I mentioned before, a defendant's general right to criticize and to proclaim his innocence. And also to have, well, and that's what I'm saying. Well, under the terms of this order, he can do it without mentioning co-defendants, witnesses, or unindicted co-conspirators.
Or facts.
So it'd have to be in broader terms.
Or
If we can
facts
fashion
related
language
to
that is more of a carve out, we'll
Ruby
work on
Freeman
that. But
and
I think for
Shane
now,
Morris.
in the short term, based on what we learned so far today and the prior history, at least for the next couple weeks, if not week or two, it'd be this.
I would imagine.
Thank you, Your Honor. May we be excused?
Because we got to go.
Sorry. Can we get a witness list? No unindicted co-conspirator number 23, unindicted co-conspirator. I don't know who those people are.
It's in his discovery, but we'll point him to the right page.
I think the indictment co-conspirators had already been disclosed, as I
They
understand
have
it.
been disclosed, Your Honor.
All right. All right. I'll let the parties work that out. But for now, Mr. Floyd, you have a copy that's been provided by the state of this modified bond order.
It used to be.
I'm letting you know that I'm signing it as written by the state,
back
and it may be modified again in the future, but for now,
Just
everything in
kidding.
this
I still have.
bond order is going to be in place upon signature, and you'll be expected to abide by it. Is that
Yeah.
understood?
So delete
All
those
right. Thank you,
fucking
Ms. Floyd.
posts, you piece of shit. Wonk! 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 Chow! 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 Chowsies! Chowsies! Little hot mic action. Chowsies! Chowsies! Oh man! Oh good! Excellent, Siegfried. See, this is like full circle. We found out that Burns with peanut butter actually did the trick. Yay. That's a happy ending to a Tuesday, let me tell you. All right, well. Wow, that's amazing. Hey, it's amazing. All right, I'm gonna I'm probably gonna go and take a shower. That would probably be something that I do, which is tastes like hell. But you know what? Fucking eat it up. I'll drink your milkshake. I'll drink it up. I'll drink your burned can of butter. I'll drink it up. No, I won't. I'm just kidding. But I might put it on some nice toast or an English muffin. Yay! All right. So see a lot of you tonight in a couple of hours. Actually, for the movie night. It's the movie night. Until we get fired! Yay! Oh, the waves have started again. Okay, I'll see you later, alligator.